Good morning. My name is Gregory Chicali, and I'm the hearing officer for the Oil Conservation Division. This is a special docket today. We have 5 cases. 3 of them are hearings by affidavit, but 2 of them are contested. We also have with us Dean McClure. He's our technical examiner this morning. Dean, are you ready to start?
Yes, sir, Mr. Examiner.
All right. Thank you, Mr. McClure. So let's begin with Matador Production, case numbers 25533 and 25534. Entries of appearance, please.
Good morning, Mr. Hearing Examiner. Paula Vance with the Santa Fe office of Holland and Hart on behalf of the applicant Matador Production Company.
Good morning, Ms. Vance. I don't think there's any other parties entered.
No, there are not.
Go right ahead.
So we're back here on these. We had a discussion at the last hearing regarding some of the wells that were originally included or which were included with the original filings. And per guidance from Mr. McClure, we filed an amended application in each of the cases requesting to remove those wells that will not be drilled within the requested period of extension, the 1-year extension being requested. Oh, I'm getting a little bit of feedback, Mr. Shikalian. Can you, I think it might be your microphone is on. I don't know. Are
you saying Mr. Zimski?
No, yours is on, but I am getting some like weird feedback. I'm
not hearing it, but go right ahead.
Okay.
Don't worry about it.
Okay. I'm just checking to make sure that you're hearing me correctly. So again, we filed amended applications, and then from there, we also filed amended hearing packets. I did include with these a updated pooling CPAC that removes the wells that we've requested to drop. And so that can be obviously added to any subsequent order. And I will note that I did file revised hearing packets yesterday afternoon. There wasn't any big issue other than I had the updated pooling exhibits swapped between the 2 cases. So nothing changed except for we put them to the correct case. And I will note, and I'm happy to share my screen and just show very quickly. There is one override in case 25533. If you go to page 23, and I'm happy to share real quick here, just so we're on the same page.
I'm not sure if you need to share. Let me ask Mr. McClure.
Okay.
Because maybe this is unnecessary. Mr. McClure, have you had a chance to review all the documents that Ms. Vance just discussed?
I have not reviewed the ones they submitted yesterday. I'm just now seeing they submitted something yesterday.
Okay. All right. Ms. Vance, what did you submit yesterday?
So it's the same exact hearing packet materials, except for this particular exhibit, the D1 for each of the cases, they were reversed. So they were just got filed with the wrong cases. So we put them with the correct cases. None of the information in them changed. It's just we want to make sure that the notice list matches the pooling exhibit, and pretty much most of the, it's mostly the same parties in each of the cases.
So Mr. McClure, now that you've seen what was filed recently, how do you feel about taking this case under advisement?
25533 we can take under advisement. I have questions for Ms. Vance on 25534 though.
Okay, is the question for Ms. Vance or for one of her witnesses?
It's in regards to how the exhibit packet is put together. So I think Ms. Vance is the most appropriate task.
Perfect. So Ms. Vance, let's get your exhibits admitted into evidence first.
Okay. I would ask that the exhibits be admitted.
Perfect. So all of your exhibits are admitted without exception. Mr. McClure, your question?
Yeah, Ms. Vance, I'm just now looking at your exhibits that you submitted yesterday, but in the exhibits that you submitted last week for case 25534, it appeared that the wrong application was attached to it, and as the original application was attached instead of the amended application. Do we now have the amended application that talks about the change in the development plan?
We sure do. I noticed that too, and I put the corrected amended application with that case. So, and I'm happy really quick, just so you can see it on the record. Since I've got this up, I'm going to show you. If we go up here, you'll see.
The paragraph 4 there, looks like.
Yeah, amended application, and this is the hearing packet for 25534. And you'll see it's got that piece in there regarding which of the wells are being asked to be removed. And again, on that, Mr. McClure, the revised CPACs, I did include in each of them. In each of those updated CPACs, I'll just go to it so you can see really quick. In the special provision stipulations, just reiterating which of the wells are being removed from the original pooling order.
Now, in your original exhibit packet, I'm scrolling at it now to see exactly. Let's see, we have the first page of the amended application submitted after the written notice. Where's my notes on here? Yeah, but we were missing the actual example of the notice letter. Is that still the case? I believe it is.
Should be in there.
Yeah, can you scroll down to your page 28 of 33 in your
Yes, I
amended
do.
exhibit?
I do see that.
Yeah, it looks like you may have mistakenly included the first page of your amended application instead of your example notice letter. Does that sound right to you?
Yes, and I can switch that out if you will let me when I get back to my office and add that notice letter. I'm not sure why I'm having issues with these hearing packets, but I can add that example of the notice letter for 25534 and get that filed when I get back to my office. It won't take me but 2 minutes.
When was written notice provided?
The same time it went out for the other case, so January 7th, 2026.
Okay.
The letters went out together.
And is the letter for this case identical to the other letter other than, well, let me look at the other letter.
It'll be the same, except for it'll reference, in the caption where it says regards, it'll reference the specific case and order number and then the associated wells. But other than that, all of the information is the exact same.
Okay, so essentially like this, I don't know, call it a header, I guess. It says reapplication of Matador Production Company to blah, blah,
Yeah.
blah. Essentially, that's the only thing that is different.
That's the only thing that's different. That's correct.
Mr. Hearing Examiner, I don't have any further questions, but we are going to need that example notice letter submitted for us.
Okay, so Mr. McClure, what is it that needs to be corrected now?
We're missing the written notice letter that was provided to the interest owners for case 25534.
Okay, so is that just that single document?
Yes, it should be a singular page here.
So Ms. Vance, this is the letter that you mailed for individual notice, the 20-day notice. All right. And do you have that?
Yes, I'm literally emailing my legal assistant right now and
Okay.
asking her to add that.
Okay, so it's a letter that was dated when?
January 7th, 2026. So it would be, the 20-day timely notice.
Okay, good. But it was dated the 7th, you said?
Yes,
Literally,
that's
down to
how our
the
notice
minute?
goes out. Yep,
right down to the minute.
right down to the minute.
Okay. Well, luckily it's 20-day calendar days, so we don't have to worry about holidays and weekends.
Yeah.
Okay, so Mr. McClure, is there anything that you need to review in that letter? Or once that letter is included in the packet is complete?
In this precise instance, based off Ms. Vance telling me that it's identical to the other notice letter with
Right.
the exception of the header, then assuming
Right.
that's correct, then would be fine without further review. The only further review would just be to confirm that that is correct. But Ms. Vance is confirming
Right.
for us that it is, I guess.
All right. Okay, so Ms. Vance, if we can rely on your your candor to the forum, then as long as you can fix this, so is this going to be yet another amended another amended exhibit packet?
I mean, I'm happy to do it that way, or if maybe I could send it and Freya wouldn't mind.
No.
No?
Freya
Okay.
does mine.
No.
So please
Okay.
Get your assistant to file, what would, it's the second amended or third amended? What is this?
It would be the second.
Second amended. Please have her title the exhibit packet, second amended exhibit packet with the cover letter
Okay,
to explain what you're including that was left out. And as long as you do that by 5 PM today, this case will be taken under advisement.
you got it.
Okay, so Mr. McClure, she has satisfied you on both cases now?
Yes, that's correct, Mr. Hearing Examiner.
Okay, and Ms. Vance, the other case will be taken under advisement as of now.
Perfect. Thank you.
Okay, Ms. Vance, I don't know if this one is also yours. This is Mewbourne Oil 25663.
It is.
Go right ahead.
Good morning, Mr. Hearing Examiner Paula Vance with the Santa Fe office of Holland and Hart on behalf of the applicant Mewbourne Oil Company.
Good morning, Mr. Hearing Examiner Yaritza Pena with Hardy McLean, appearing on behalf of COG Operating, ConocoPhillips, Contra Oil and Gas, and Marathon Oil Permian in this case, and we still have an objection on this case.
Perfect. Thank you, Ms. Pena.
Good morning, Mr. Examiner. David Kermsey of Bradfute Sayer, representing PBEX. We're just making an entry of appearance, no objections.
All right, thank you, sir. Ms. Vance.
So these cases I'm just going to give a little color on the background. These cases have been around for almost a year now. Originally, they were filed as case
We only have one case in front of us. What are you saying these?
So there was a case a prior lead belly case, 25228.
Okay.
That was filed in February of last year. There was a contested hearing that was supposed to take place between Mewbourne and PBEX. That went away in July. Mewbourne refiled their case in July. We had a hiccup in our application, filed an amended application. I believe that was in November. Then COG Marathon, they filed an entry of appearance and objection in December. The holidays came up. The parties are working on an agreement. I know that because I talked with Ms. Hatley actually yesterday. I know she's out today and Ms. Pena is here for her. I'm not trying to speak on your behalf, but I did talk with her yesterday. But it's my understanding they should have the letter agreement. They are reviewing it right now. And our hope is that we can go forward by affidavit at the February 5th docket if we are able to continue it. There's just been a lot of moving parts with this between the three parties, but I think we're finally in a place that given that little bit of extra time, we should be able to move forward by affidavit.
So in other words, you're not ready to go forward now?
No.
This case was filed when?
This one was filed in July after that contested hearing went away. Then we were going to go to hearing and in October, And then we had, there was, Mr. McClure brought up, there was a issue in the legal land description. We filed an amended application in November. And then, holidays came up. Marathon COG had that entry of appearance and objection. The parties, from what I understand from having talked with Ms. Hatley, they just want to get the letter agreement in place and allow us to move forward. But obviously it won't, I'm just going off of the conversation that I had yesterday.
But
So,
we don't have Ms. Hatley here today.
no, Ms. Pena,
Oh,
she's here.
Ms. Pena?
Yes, that is correct. I talked with Ms. Hatley yesterday. She wasn't able to be, excuse me, on the hearing today. And we would like a little bit more time for them to reach that agreement. And I think that they were okay with the February 5th continuance, so that they can finalize the agreement and we can remove our objection and that the case may proceed by affidavit at that point.
When you entered your appearance just now, you said there was no objection.
I said we do maintain our objection. I'm sorry if that
Oh, I
didn't
didn't
come
hear
through.
you. I did not hear you. Okay, what is the issue that's being negotiated?
I would not have an answer for that.
Ms. Vance?
My understanding is it's a business, that's beyond the scope of my understanding. Those are internal, business negotiations. So I don't want to put anything on the record that would be inaccurate, but I do understand that they have an agreement that they're trying to work towards. And they just wanted more time to review the letter agreement that was sent from Mewburn over to COG.
So you're asking for a continuance to February 5th?
Yes.
Okay, now if I grant that continuance, it is the last continuance. This case is very old.
Yes, I completely understand
Okay.
that. And that's why I wanted to provide some color and
All right,
plead
got
for
it.
the request.
So I'll grant the continuance. So you'll move the case yourself.
That's one thing that I was going to ask, and I did send an email to actually Ms. Pena's colleague this morning since COG Marathon wanted additional time to review the letter agreement. They just asked that COG Marathon continue the case for me.
So you're not going to continue it. Someone else will continue it.
We would ask that Mewburn or that Marathon COG file the continuance.
Pay for the continuance.
Yes,
Okay, to February 5th.
yes.
And so, Ms. Pena?
I will relay that information to COG. I don't think I got your email this morning, Ms. Vance. Maybe Ms. McLean got your email, but I'm sure we can coordinate on what is being asked for that continuance for February 5th.
So February 5th is literally next week.
Yes.
Okay, next Thursday. Okay. I'll grant the continuance to next Thursday as long as it moves forward as a hearing by affidavit. We'll hear it. If there's any more delay, the case will be dismissed.
Understood.
All right. Anything else, Ms. Pena?
Nothing else for me. Thank you.
All right, Ms. Vance, does that conclude your business today?
I'm going to make an entry of
You
appearance
are,
in your
okay.
next two cases.
All right, excellent. Well, we're off the record in that case. Moving on to cases 4 and 5 on our docket. This is Pride Energy, case 25564, and Coterra Energy, 25562. Entries of appearance, please.
Sharon Shaheen on behalf of Pride Energy.
Thank you.
William Zimsky on behalf of Coterra Energy.
Thank you. And who's sitting next to you?
Next to me is Olivia Atkins. She's a law school graduate and sitting for the bar in New Mexico in February. And we
Wonderful.
wish her luck.
Definitely.
Not that she needs it.
All right, excellent. Okay. First, let me ask the parties, are there any preliminary matters that we need to deal with? Oh, go ahead, Ms. Vance.
I just want to make my entry of appearance on behalf of MRC Permian Company. In both of the cases, we are just monitoring.
Okay, are there any
And-
other entries of appearance?
Yes, Mr. Hearing Examiner Yalitza Pena on behalf of COG Operating, ConocoPhillips, Contra Oil and Gas, and Marathon Oil Permian, and we are also just monitoring.
Thank you.
Thank you.
Do the parties know of any other entries?
I thought there was one other entry of appearance, Marathon.
I may have been cut off, Ms. Shaheen, but we are all, Yalitza Pena on behalf of Marathon Oil Permian as well.
That's it.
All right, now that we have the entries of appearance done, are there any preliminary matters that we need to deal with?
I did file objections to parts of Mr. Weinkopf's testimony.
Okay, when did you file them?
I filed them yesterday morning at about 8:50 is my guess.
Okay, so you filed objections to which exhibits?
Paragraphs 9 through 13, I believe, of Exhibit C.
Exhibit C. Okay. Any other objections?
Not at this time.
Okay. Are there any other preliminary matters from Pride that we need to deal with?
I believe we've had some back and forth. I've conferred with Mr. Zemsky about how we should proceed
Sure.
today.
Sure.
And I'm sure that you'll let us know how you would like for us
Okay.
to proceed today.
All right.
I'm willing to do whatever pleases the hearing
Okay.
examiners.
Okay. Well, before I go to Mr. Simsky, what did you discuss about how to proceed today?
Mr. Zemsky proposed a certain order
Right.
of
What is that?
offering testimony. He believes that Pride should go first
Okay.
with its direct, and that Coterra would go second with its direct,
Yes.
and then Pride would do its rebuttal case. Coterra would do its rebuttal case. Please correct me if I've got that wrong. But what I would just say is that I believe both parties should be able to address any new evidence that comes forward. And I don't know that we should be restricted to the strict back and forth that
Sure.
Mr. Zemsky has proposed.
Typically, what we've done before is that the parties, and I don't know who wants to go first, but it sounds like, and you're okay with going first, Machine?
Yes,
Okay, perfect. Whatever party presents evidence, they present both their direct and their rebuttal at the same time, as opposed to coming back and doing rebuttal afterward. Is there any reason why you can't do that, Machine?
we can do our best, but we do want to reserve the right to come back after they've testified and address any additional information that they've testified about.
And Mr. Zemsky?
We have no objection to proceeding like that.
All right. And everyone's witnesses are virtual?
Yes,
How many
Yes.
witnesses do you have, Machine?
3.
3. And Mr. Zemsky?
4.
3 and 4. All right. Now, do you have any preliminary matters before we begin?
Well, we did file an opposition to Pride's objection to Mr. Weinkopf's testimony.
Okay, we'll get to that. Let's get to that. What I want to do next is, if those are the only preliminary matters, it's dealing with this testimony. What I'd like to do next is I'd like to deal with the exhibits, and let's see what we can stipulate to between the parties and what we can't. Now, obviously, you've just told me you have a problem with one of the exhibits, the paragraphs 9 through 13. But let me start with you, Masheen. Do you object to any other exhibits filed by Coterra besides Exhibit C, paragraphs 9 through 13?
Well, I would note that with respect to their rebuttal exhibits, I believe that those rebuttal exhibits should have been part of their direct case. Now, that said, assuming we get to respond to those exhibits, I don't think we will stand on an objection.
So then is your argument a legal one or is it a procedural one? And that's important because if you're saying that, hey, these are not true rebuttal exhibits, these should have been anticipated, they're direct exhibits, and they shouldn't have a rebuttal case, that's one argument. If the argument is, okay, they have some exhibits, but we need time to address them, that's a different argument. Which is your argument?
The first.
Oh, it is the first.
Yes, there is testimony, and I believe it's in Mr. Weinkopf's statement, and it is part of the testimony that I've objected to, that I believe their rebuttal exhibits should have been offered in support of that testimony. Now, if that testimony gets excluded, of course, then those exhibits, I suppose, could be considered rebuttal, but I believe they should have been offered as part of the direct case.
Okay, So, Mr. Zimsky, I'll get to you in just a minute. I want to hear from you, obviously. But Ms. Shaheen, what will you stipulate? Let me ask it this way.
Mhm.
You have a list of their exhibits. You've seen all of their exhibits, both rebuttal and direct. What exhibits will you stipulate to?
Sorry, I'm looking for their list of exhibits.
Do you want me to start with Mr. Zimsky or are you
No,
okay?
I'm there.
Are you there? Okay.
Okay. Um, So I don't have any objections to Exhibit A, Exhibit B, Exhibit C. We've discussed the objections I have to Exhibit C. And that would include the objections that I have with respect to Exhibit C, would include the related exhibits to those paragraph numbers that I previously identified. And that is C1, C2, C3, C4, C5, and the rebuttal exhibits.
Okay, now, Ms. Shaheen, I'm trying to make this list something that I can refer back to easily. So
Okay.
I understand that you do not object to Exhibit C outside of paragraphs 9 through 13. Is that right?
That's correct.
All right, now you're listing other things. Are those rebuttal exhibit numbers that you're now giving me?
They're the sub-exhibits to
Oh.
Exhibit C.
Okay,
So I don't, well, actually, I guess I've, with respect to their sub-exhibits, I don't object to Exhibit C6 or Exhibit C7.
okay, so then in other words, and these are all direct exhibits, right?
Yes,
Okay, so you are accepting, or I can admit through stipulation, Exhibit A, B, C with the paragraphs that you've mentioned as objected to, C6 and C7.
correct.
What about the sub-exhibits to A and B?
No objections.
Aha, okay, so I didn't understand that now that you're saying this. Okay, are there any other exhibits that you will stipulate to at this point?
We stipulate to both Exhibit D and Exhibit E.
I didn't hear the last letter.
Exhibit E, that's
E,
the
D and
notice. Mhm.
Okay, so then there's D and then there's E and all the sub-exhibits to D and E.
That's right.
All right, so here's what I have, Mr. Zimke. I have A and its sub-exhibits, B and its sub-exhibits, C excluding 9 through 13 paragraphs, C6 and C7, all of D, all of E. Now, excuse me, rebuttal exhibits, are they labeled differently?
They are labeled
How are
differently.
they labeled?
Their rebuttal exhibits, I believe, are labeled one rebuttal exhibit
Ah,
1
okay.
through rebuttal exhibit 4,
And you object to all of them?
because they should have been
Right,
part
but
of.
you're not admitting those through stipulation at this time?
That is correct.
Very good. I just want to have a complete list here. Okay, Mr. Zimsky.
Yes, Coterra doesn't have any objections to any of the exhibits being proposed by Pride, subject, of course, obviously, to cross-examination.
Okay, so, and I appreciate that. So let me, on the record and for the court reporter, you got the list that has been admitted by, you have a list of Coterra's exhibits that have been admitted through stipulation. Yes. All right, you have that list. Okay. And for Pride's exhibits, all of them are admitted through stipulation without exception. Okay, now, Mr. Zimsky, what I'd like to do is I'd like to hear your argument on the rebuttal exhibits now. And then what I'd like to also deal with is for Exhibit C, the parts that have been objected to, I'd like to hear, what I'd like you to do is once we get your witness sworn in, I'd like you to provide a foundation for the, in your own course of events, whenever you get to see paragraphs 9 through 13 and C1, C2 through 5, you lay a foundation for why I should overrule the objection to the exhibits. Does that sound fair?
Yes.
All
it
right,
does.
excellent. So what is your argument to the rebuttal exhibits?
Well, we have 4 exhibits. Rebuttal exhibit 1 in the, we haven't filed these since they haven't been admitted, but we did send Freya an email to forward to you so you'd have them, but can you share?
You're talking about the rebuttal exhibit?
Yes. So
My-
I'm going to share the rebuttal exhibits on the screen.
What I'm asking, if you will just confine your argument to why are they true rebuttal exhibits? What I've heard from Ms. Shaheen is these aren't proper rebuttal exhibits. And as a trial lawyer, as a criminal trial lawyer, I understand the difference between a true rebuttal exhibit and a rebuttal exhibit that is called a rebuttal exhibit, but it really should have been part of your case in chief.
Yes. Rebuttal exhibit number 1
Mhm.
is in rebuttal of the statement of the engineer, Pride's engineer, Will Guilford, at paragraph 5. He has a couple bullet points.
What exhibit are you, can you be specific about, you mentioned the name of a witness, but what exhibit does this rebut?
This rebuts the statement of Will Guilford, who is, I think, exhibit C.
Is that correct, Machine? Wait, your microphone wasn't on.
Yes.
So, Mr. Zimsky, so I'm writing this down, so I have to be clear, and it's for the court reporter as well. So your rebuttal exhibit 1 rebuts their Pride's exhibit C.
Correct.
Any particular part of it?
Paragraph 5.
5, okay,
There are 4 bullet points.
okay,
And they, the gist of which is that the Pride targeting the upper Wolfcamp interval of the Wolfbone pole is superior optimal target depth as opposed to Coterra, who was targeting the 3rd Bone Spring sand interval. And this exhibit shows that in this area, if you look at the
when you say
lower-
this exhibit, please be specific.
the rebuttal exhibit number 1,
Okay, fine.
which is on the screen.
Yep,
And I'm going to object to showing these on the screen. I believe it shows the examiner's evidence that may be excluded, and I don't think it's proper to show them on the screen.
okay, so Mr.
It's fine.
Zimsky, do me a favor, please don't share your screen just yet. I understand it may not be the weightiest legal argument, but I don't think you need to show me anything right now. You're just making the argument right now and why this was a surprise.
Okay.
That's really all I want to know.
Yes, and I would not have published that in front of a jury,
I
you
understand.
know, obviously.
And
you
we're
would be
not in a
yelling at
criminal
me if
court,
you would be
obviously.
yelling at me if I had.
Right. Why is it a surprise, the paragraph 5 of Pride's Exhibit C?
Well, it's a specific argument that they're making that we're specifically rebutting,
Okay,
you know, and that's the gist of our, you know, rebuttal argument. That they are saying that the wolf bone is, the upper Wolfcamp is better than the Bone Spring. And we do make that argument in direct, but we're providing rebuttal to his specific arguments that he's making in his direct testimony that we did not see until after we filed our exhibits.
okay. Let's go on to rebuttal Exhibit 2.
Now, rebuttal exhibit 2 is specifically addressed to Pride's exhibit A,
A,
the statement of Matt Pride, the landman.
okay.
And Ms. Shaheen, is that the correct designation? Is that exhibit 1 or exhibit A?
Mr. Pride's testimony is exhibit A, yes.
Perfect.
So specifically at paragraph 14, he states, in a little factual background, Coterra has been granted operatorship of 1st Bone Spring and 2nd Bone Spring in the subject lands. Mr. Pride is making the point that he specifically how anticipated production from the first and second Bone Spring wells does not justify drilling these wells with today's oil prices. Now, that's something that, that as far as we're concerned, came out of left field.
Okay.
We don't think there's any basis for it.
All right.
And so we, Coterra Rebuttal Exhibit 2 and Rebuttal Exhibit 3 are both addressing that point. Coterra Rebuttal Exhibit 2 provides the economics of first Bone
Okay.
Spring laterals, and Coterra Rebuttal Exhibit 3 does the same thing with second Bone Spring laterals to directly rebut Mr. Pride's assertion that the anticipated production from first and second Bone Spring wells does not justify drilling these wells at today's prices.
Okay. And finally, number 4.
Number 4 is just a reference well list. It refers to all the wells that were referred to in the rebuttal exhibits 1 through 3.
So it just supports the other
Yes.
through reference well numbers.
Yes, it just so people can check our work.
All right. So, Ms. Shaheen, you've heard the argument of why this was surprise and that these are true rebuttal exhibits. What is your argument?
In Exhibit C, Mr. Weinkauf's testimony, particularly paragraph 14, Mr. Weinkauf discusses the oil productivity of both the Bone Spring and the Wolfcamp.
I'm confused, but you just said paragraph 14. I thought we were dealing with paragraph 5 in Exhibit C, so I'm confused.
I'm referring to Coterra's Exhibit C.
I didn't know that.
Sorry. My apologies for not being clear. But as part of the direct case offered by Coterra in Mr. Weinkauf's testimony in Exhibit C,
Okay.
I believe paragraph 14 talks specifically about the productivity of the Bone Spring and the productivity of the Wolfcamp.
Okay.
And these exhibits could have been offered in support of that statement.
Okay, so let's stop for a moment. Let's deal with this one at a time.
Okay.
Mr. Zimsky, you've heard the counter argument, why this isn't a surprise.
Well, in Mr. Guilford's statement, his bullet points.
Can you please use exhibit letters and paragraphs so that I can follow this argument?
Pride Exhibit C.
Yes.
Statement of Guilford, paragraph 5.
Yes.
4 bullet points. And he's making arguments about frackings going up and down.
Yes.
And that was, that's something that that was an argument that they're making here. And
for the first time.
For the first time. And so we're saying that our argument is the third Bone Spring is the optimal target zone.
Mm-hmm.
And their argument is the counter argument.
Right.
So we're rebutting their counter argument.
Right.
And that's the purpose of the rebuttal exhibit number 1.
So, Ms. Shaheen, what I'm hearing is while there was that their witness in their exhibit C, paragraph 14, as you remember it, touches on the economics of the development. Your witness brings up more specific fracking that their witness is now rebutting.
Right, but the rebuttal exhibits that they're offering do not address fracking.
Ah.
Well,
Mr. Zimsky?
They do address, they're looking at it from it's the counter argument to the Upper Wolfcamp is better than the third Bone Spring. Our direct case is that the third Bone Spring is the better target zone.
Mm-hmm.
So we're just countering, the argument that it's assumed, I mean, the fracking, we don't mention fracking going up or down in the rebuttal exhibit number 1, but that is assumed within the exhibit that shows the averages of the third Bone Spring wells being better than the upper Wolfcamp wells.
So Ms. Shaheen, let me ask you something here, because really now, I understand the arguments now much better than I did before. And while I could take a very hyper-technical view of what is rebuttal and what is not, it all seems as though it's relevant. I don't know how reliable it is because we haven't dealt with that yet, but it all seems relevant. And if I did exclude it as a rebuttal evidence, I would think it would come out during cross-examination of your witnesses and possibly, I'm just not sure of the benefit of excluding it, given that the administrative forum is very welcoming to evidence, and the rules of evidence don't apply here. So I have to make a decision on whether it's relevant and reliable. And moreover, I have to make a decision on whether it's fair to you. Well, ultimately, I mean, that is in my mind all the time. Is it fair to you? It seems to me that if I give you an opportunity for your witnesses to then argue that that information is either unreliable, irrelevant, or incorrect in some way, as long as I give you an opportunity to provide a full and fair record for this division to make a decision on, then it's not that critical that I make a determination that it's true rebuttal, it's not true rebuttal, et cetera. What do you say to that?
You hit the nail on the head. We received these exhibits last night, and there is a lot of information that is reflected in these exhibits, and we didn't have any time whatsoever to examine the underlying information that's reflected in these exhibits.
That's a great argument, and that one I can totally support. So with that in mind, I overrule the objection that these rebuttal exhibits are not true rebuttal exhibits, because Mr. Zimsky did make a cogent argument on why they are rebuttal. He specifically goes through your exhibits and what paragraphs and letters that he's rebutting. However, I'm going to bend over backwards to give you and your witnesses the opportunity to fairly evaluate the evidence and to put on whatever information you feel you need to. Would you find out from your client how much time it will take for them to review this evidence and be prepared to testify after your direct case? And your direct case has some rebuttal evidence as well, right?
Yes.
I thought-
Well, we
No.
do have rebuttal that we will offer when we offer our direct case.
Right.
Okay.
Right, that's what I'm saying.
Mhm.
But it sounds to me like what you're asking for is some more time after you present your case to then deal with this new evidence, right?
Yes. It would be helpful for me to talk about that with my client.
Right.
Okay.
So why don't you do that while we're dealing with, because you're going to go first. So you're going to have plenty of time to put on your case. Then we'll hear from Mr. Zimsky with his case. And then you will, at some point during all that, let me know when your witnesses, or if you have new witnesses. I don't know if you're going to have different witnesses to deal with this rebuttal. I'm going to give you leeway, is what I'm saying. Does that sound fair?
It sounds fair. I just don't know that we can turn it around today while
That's
we're
okay.
in the
We
middle
can
of a
come back
hearing.
tomorrow. We can come back tomorrow. We have time tomorrow. That's why we hold these on Tuesdays, so that Wednesday is an overflow day for this. Okay?
Okay.
So that seems fair to you?
Yes.
All right, Mr. Zimsky, any objection to what I've ruled?
No, Your Honor.
All right,
Mr.
I get it. Whatever, I get the point. Okay, so now your rebuttal exhibits are admitted into evidence. We're still having a problem with paragraphs 9 through 13, which you'll deal with when you have your witness on the stand, and your C1 through C5. Those are not, C1 through C5 are not admitted yet, okay?
Yes.
Did I miss anything, Ms. Shaheen?
No.
All right, good. Mr. Court Reporter, did you catch that?
I did, yes.
All right. Okay, So, Ms. Shaheen, would you make a brief opening statement? First of all, you said you had 3 witnesses and you have 4 witnesses. Or did I get that backward?
That's correct.
All right. May I know, let me just put down here. Is Ms. Shaheen for Pride, who are your witnesses?
Our land witness is Matt Pride.
Matt Pride. Okay.
Our geologist witness is Harvin Broughton.
Harvey what?
Harvin, Harvin,
Sorry,
Broughton, Broughton.
Thank you.
And our engineering witness is Will Gifford,
And when you say engineering, do you mean like reservoir engineering?
petroleum engineering.
Not reservoir engineering, petroleum engineering.
Yes,
Okay. What's the difference?
I think petroleum engineering is broader.
Broader. It sounds broader, doesn't it? Okay. And his name is Will what?
Gifford,
Gifford, thank you.
Gifford.
Mr. Zimsky, who are your witnesses?
We have 4 witnesses. The first will be Ashley St.
Oh,
Pierre,
I remember her. Yes.
our landman. Second witness will be Stacy Fry,
I remember her too.
our geologist.
Mhm.
Third witness is Kent Weinkoff, our reservoir engineer.
He's a reservoir engineer.
Yes.
Okay.
And our fourth witness is Calvin Boyle, who is a facilities engineer.
I remember him too. I think I've had contested hearings with Coterra before, and 3 of these I remember their names. Are all 4 of your witnesses accepted by this division as experts in their field?
Yes.
Okay, because I did not recognize the reservoir engineer's name. So great. So they're all accepted. Fantastic. Miss Shaheen, the same question to you.
Mr. Pride and Mr. Broughton have both testified before the division. Mr. Gifford has not.
Perfect. All right. So we need to qualify him. Okay, very good. And we'll do that when you call him. I think what I'll do is I'm going to ask you to have, are your witnesses all available, Mr. Zimsky, now?
I believe they are. They better be.
Ms. Shaheen, are your witnesses available?
I believe they are. I haven't checked.
Let's get
in
them
the last
all on
10
the screen. So I'd like to see 7 faces on the screen for me. Let's get them all sworn in together. Actually, I do recognize Mr. Weinkauf. Good morning.
Morning.
1, 2, 3, 4, 5. 2 more. Oh, there's Miss St. Pierre. Perfect. Thank you. Would all 7 of you raise your right hands, please? Do you swear or affirm under penalty of perjury that the testimony you're about to give is the truth, the whole truth, and nothing but the truth? One at a time, please.
Yes.
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 Perfect. I heard 7 yeses, or actually, I think I heard more than 7, but thank you. Okay, so you can all put your hands down. One at a time. Let's start with Mr. Pride. Mr. Pride, please say who you are employed with and please spell your name.
It's Matt Pride, M-A-T-T, last name P-R-I-D-E. I'm employed by Pride Energy Company.
Okay, and you have been qualified as an expert in what field before this division?
In land.
Perfect. Thank you, Mr. Pride. Mr. Weinkauf.
My name is Kent Weinkauf, Kentweinkauf. I work for Coterra Energy, and I am an expert witness in reservoir engineering.
Perfect. Thank you, Mr. Weinkauf. Ms. Fry.
My name is Stacy Fry, S-T-A-C-I-F-R-E-Y, and I'm a petroleum geologist for Coterra Energy.
Perfect. Thank you, Ms. Fry. Mr. Gifford.
My name is Will Gifford, spelled W-I-L-L-G-I-F-F-O-R-D, and I'm a petroleum engineer employed by Pride Energy.
But you have not been accepted by this division as an expert in that field?
Correct.
Great. We'll come back to you. Thank you, Mr. Gifford. Mr. Broughton?
My name is Harvin Broughton. I'm retained as a contract geologist by Pride Energy.
And have you been accepted as an expert in your field by this division?
Yes, I have.
All right, perfect. Thank you. Ms. St. Pierre?
My name is Ashley St. Pierre, ST period space PIERRE, and I'm a petroleum landman for Coterra Energy.
Perfect. And finally, Mr. Boyle.
Calvin Boyle, CalvinBoyle, and I've been sworn in as an expert facility engineer for Coterra Energy.
Perfect. Thank you. I want to start with Mr. Gifford. Mr. Gifford, I want to get you qualified as an expert before this division. I do not have your CV in front of me. Did you file one?
Yes, it's
Okay.
attached to Exhibit C.
I don't need to see it yet, and I may not need to see it at all, Mr. Gifford. What I'd like to hear is, first of all, what field of expertise are you seeking to be qualified today?
Petroleum engineering.
Petroleum engineer. Okay. What does a petroleum engineer do?
I would say that it depends what size of company you work for. The larger company you work for, you're more specialized. In the smaller company you work for, you wear many hats. Worked for different sized companies and have been very specific in what I've done in my past compared to what I do now at a smaller company where I do more work across the different disciplines of petroleum engineering.
Perfect. Okay. So what education do you have? But that still doesn't tell me what a petroleum. So let's take for Pride, where you wear a larger hat. What does a petroleum engineer do?
I'm part of the team dealing with operations, production, reservoir, drilling and completions, facilities. So, you know, at a small company, you wear many hats. You're involved in all the projects and working on everything.
Okay, I understand that. I still don't feel like I know what a petroleum. What are the typical? Okay, take a larger company where your duties are more narrow. What does a petroleum engineer responsible to do? What is your product?
Well, I would say that most larger companies do not employ a petroleum engineer under the title of petroleum engineer specifically because they're going to be very specific in what they do, where the petroleum engineer by degree would be employed to do specifically reservoir engineering, production engineering, drilling engineering, completion engineering, or work in facilities. So I would say that you could do any of those disciplines within a larger company.
Okay, let me ask Mr.
Engineer.
Okay, thank you, Mr. Gifford. Let me ask Mr. McClure. Mr. McClure, when you're listening to Mr. Gifford today, what is the scope of his expertise that you are listening to?
What was he entered in as?
He's not been entered. He's seeking to be admitted as a petroleum engineer.
Well, let me look at his, Mr. Zimsky, what page is his self-affirmed statement on?
It would be Ms. Shaheen. It's Ms. Shaheen's witness.
Ms. Shaheen, the same question? Your microphone name
54?
on.
54, Mr.
And I'll just note, it appears we did inadvertently omit Mr. Gifford's resume.
Yeah, I don't see it. I'm looking at, yeah. There's nothing to look at, Mr. McClure.
The statement, though, is at page 54.
Right. Well, let me do it this way, Mr. McClure. Why don't you listen to the questions I'm going to ask, and if that suits you, then we'll get him admitted. All right. So, Mr. Gifford, what education do you have? Please tell me your degrees and when you've earned them and where you earned them from for this degree, for this specialty.
Sure. So I earned my Bachelor of Science in Petroleum Engineering from the University of Oklahoma, and I graduated in 2016.
Okay. Is there any other continuing education that you've done?
No.
Okay. All right. Is there a society of petroleum engineers that you belong to?
I'm not active in Society of Petroleum Engineers or the AAD, but I was a member during my time in college, and I'm technically still a member. I'm just not active, but yes.
Okay. All right. So after 2016, what work have you done give me dates, give me companies, because we don't have your CV. Give me dates, give me companies and your duties at those companies.
Sure. But first, I'd like to start. I started interning for oil and gas companies in 2010 during my time in high school. In total, going, I believe, after the summer of my sophomore year in high school through college, I totaled 7 internships. So I just think that's relevant to note for 3 different companies. And then upon graduating, I started working with Sanchez Oil and Gas. I worked in the field for them, and my duties, I guess, were more of a field role, more of a starting role, entry-level role. I handled a lot of optimization for about 400 wells within the Eagle Ford. I was involved in learning about workover operations, production operations, facilities, SCADA. I was assisting the more senior engineers, making recommendations on wells, optimizing wells. So that was how I got started. That was started in 2017, beginning of 17. 18, I was still with Sanchez. I moved to Houston. I had several roles there. Briefly, I held an optimization or project engineering role for them, which was a bit of a promotion, but it essentially, it was a specialty type role where I was dealing with fixing problems that we had at the time with, SCADA. I was also working on algorithms to develop detection for artificial lift, downtime, and closely working with data science on that to develop the ability to increase downtime, increase production. I'm sorry, decrease downtime and increase production. And then was promoted to a production engineering role, specifically worked for Sanchez as a production engineer up until the end of 18, I believe, just the beginning of 19, in which I transitioned to working with Maverick Natural Resources. And with Maverick Natural Resources, I worked as a production engineer for the vast majority of my time, I believe from 19 through 21. And then in 21, I became a reservoir engineer for Maverick. And I worked as a reservoir engineer for Maverick up until the time when I had the offer to go work for Pride Energy. Then I moved to work with Pride Energy, and I've been a petroleum engineer with Pride, where, as I'd mentioned before, my duties are more variable here. I do oversee production operations and workovers, and I'm involved in the projects that we have going on with DNC and facilities. And I'm involved with our reservoir engineering here. But I'd say that my primary duties at Pride Energy are involved with production operations.
All right. Mr. McClure, do you have any questions for this witness?
Not at this time, I don't.
All right, perfect. Mr. Zimsky, do you have any questions for this witness?
No, I do not.
Okay. Mr. Gifford, thank you. We here on in qualify you as an expert in petroleum engineering. Thank you. Okay. Ms. Shaheen, would you make a brief opening statement on why this division should award Pride Energy this application?
Yes. Our pre-hearing statement goes into a little more detail, but I'll note that with respect to the 7 factors, we believe the geological evidence is really not disputed. As for the risk in development, Coterra's proposal risk leaving reserves in the Wolfcamp because of its target in the third Bone Spring, because as Mr. Zimsky mentioned, fractures usually go up and recover reserves above the wellbore, above the wellbore and not down. This factor,
Mr. Hearing Examiner, I hate to interrupt, but I would object to her characterizing that that's what I said. I was repeating what their engineer said. So I wasn't,
Okay.
and I apologize for interrupting, but I had to.
Okay. I understand why you interrupted. Ms. Shaheen, and this is not evidence. This is just you're basically giving us a little bit of an overview of what you believe the evidence will show and why we should award this to Pride as opposed to Coterra. If you could kind of keep it a little bit higher level and instead of
Okay.
making an argument based on that, if you'll just tell me on a high level,
Mhm.
what evidence are you going to bring out through your witnesses that would allow the division to award this to Pride?
Okay. With respect to risk and development, we're going to present evidence that fracs usually go up
Okay,
and don't go down,
okay,
which means that Coterra's risk is lower and is more likely to recover a greater amount of hydrocarbons because its target is lower than Coterra's target. With respect,
now you said Coterra's risk is lower and would produce more hydrocarbons. You meant Pride's.
yes,
I'm
I did
assuming.
mean Pride's. If I said
You did,
Coterra,
and
yes.
that's why I
Okay.
was surprised when you said it.
Thank you for clarifying for me.
Welcome.
With respect to the third criterion, good faith in negotiations, these cases have been pending for over 4 years. Pride first filed its application to drill this well in May of 2022. Coterra, there were a number of continuances. Coterra finally, 9 months later, sends out a well proposal and files its application. It's been sitting on its hands for quite some time. In fact, it operates 2 Bone Spring wells nearby since it says in my pre-hearing statement what date it was. I want to say about 10, 12 years ago, and waited until Coterra proposed its well to even suggest development of this area. And for these reasons, we believe that Pride wins on the good faith and negotiations criterion. With respect to prudent operations and prevention of waste, both companies have a history of drilling and operating horizontal wells. Pride, however, has been in business since 1981, which is about 45 years, I believe. I haven't done the math, but I think that number's been floated around. Whereas Coterra is actually, its parent companies are younger than that. Pride has extensive experience in 9 different states, including New Mexico, and we'll have evidence that talks about Pride's experience further in this area. For this reason, and the others that we've discussed, this factor therefore weighs in favor of Pride. Comparison of costs, the difference between the 2 AFEs is close to 1.4 million. Pride's AFE is almost 1.4 million less than Coterra's AFEs. It wins on the comparison of cost issue. With respect to working interest, we concede Coterra has a greater working interest here. So they win on that factor. With respect to the service factor, Pride wins. Pride operates 6 wells in Section 13, including 5 horizontal wells. And we have facilities that will be used for the well that is proposed now. We do not have to build a new facility. We just need to create a flow line that takes us to the existing facility. Therefore, surface impact is much less and cost is much less. Pride therefore wins on that factor. Our analysis is that Pride wins on 5 factors and therefore its application should be approved. Now, just for the divisions, just a reminder to the division, there were a couple of disputed issues in the previous cases, one being allocation, because there is a depth severance here. However, the depth severance is only between Coterra and Pride. Coterra and Pride have agreed to allocation based on surface acreage. So I think that's important. It actually is helpful for both parties. And we've also agreed on the drilling cost, the overhead cost. We did notice our folks that in our original application, we requested $8,000 a month and $800 a month. We've since agreed with Coterra. They had initially proposed $12,000 and $2,000, which I thought was a little odd, but as I say, the parties have agreed $10,000, $1,000 are reasonable cost. So subject to objection from any of our working interest owners who are being force pooled, we've agreed those are the reasonable operating costs or overhead costs. And with that, Pride's application. We ask that it be approved.
Okay, and Ms. Shaheen, you said that 5 of the 7 factors weigh in favor, in your view, to Pride. So one of them is interest ownership. What is the interest ownership?
Oh, let me turn back to my. Pride owns 12.5% and Coterra owns 41.25%. I understand that Coterra has received some elections to participate, which incrementally increases its interest. However, we will offer evidence that one of the parties who has signed an election to participate with Coterra has also signed an election to participate with Pride. So.
And what is the other factor? So I didn't hear which is the second of the 2 factors that you believe weighs in favor of Coterra. There's the interest, and what's the other one?
I think that's the only one. The other factor is split evenly. The geological evidence, I don't believe there's a dispute about the geological evidence.
Perfect. Yeah, you did mention that there's no, okay. Mr. Zimsky, I'll ask you to make an opening statement before you present your case, as opposed to now. Do you have a problem with that?
No, Your Honor, that's what I was hoping to do.
Okay, perfect. So, without further ado, which of your witnesses do you want to call first? Mr. Pride.
Mr. Pride.
Is the company name for Mr. Pride?
Yes, and we'll talk a little bit about that.
Oh. We have, Mr. Pride, I don't see you yet. There you are. Okay. Now, Mr. Pride, we have admitted all of Pride's exhibits into evidence. So, with that in mind, and you are already sworn in, with that in mind, I'm going to ask the parties to, with the exception, of course, of your Mr. Weinkauf, because they have not all been admitted under his testimony. So we'll deal with him a little differently. But for all the different witnesses today, please give us summaries. We have your direct and rebuttal testimony in evidence. You don't need to repeat it verbatim. Just give us summaries of your evidence, okay?
Yes.
I can't hear you, Mr. Pride.
Yes.
There you are. Okay. And please try to speak up because it's a little low and the court reporter needs to hear you. Ms. Shaheen, go right ahead.
Thank you. Mr. Pride, you previously informed the division that you're testifying here as a landman. Is that correct?
That's correct.
But your role at Pride is more than a landman. Is that right?
Yes, that's right.
Can you describe your position at Pride for the division?
Yes, I'm a co-owner of Pride Energy Company, as well as I handle all the land and legal aspects of the company, among many other items as well.
And how long has Pride been in business?
Since 1981, right at 45 years this year.
And then how many states does it operate?
We operate in 8 different states.
And how long has Pride been in New Mexico?
For over 25 years.
Turning to your exhibits, Exhibit A1 is the C101 for this well, is that right?
That's correct.
And it's been revised to refer to the Sharb Wolfbone Pool, is that correct?
That is correct.
With respect to your A2, is this the list of working interest owners?
Yes, it is.
I think, and Freya just stepped out, so she's not there to turn off someone's microphone. If someone has their microphone on and they're not testifying, would you please turn it off to avoid this repeat? Go ahead, machine.
Yeah, I muted Mr. Zimsky.
Oh, thank you.
Thank you, Mr. McClure.
That's okay. Thank you, Ms. Simpson. Go right ahead, machine.
Turning to your Exhibit A2, and you know what? I think I'll share
Go right ahead.
now. And turning to PDF page 18. Is this the list of parties that Pride proposes to pool?
Yes, it is.
And as I mentioned earlier, did you receive an election to participate recently from one of these owners?
Yes, we did.
And
Ms.
which
Shaheen?
owner? Yes?
I think you might be sharing your wrong screen if you tend to be sharing your exhibits.
Oh, I was sharing this screen. Okay, let's figure this out. Thank you, Mr. McClure. Is that better?
Yes, ma'am.
And going back to the election to participate that you received, Mr. Pride, which interest owner provided you with an signed election to participate?
It's Crump Family Partnership Ltd.
And you've conferred with a number of these working interest owners, is that right?
Yes, I have.
And in terms of their position on participating one way or another, what is the general message that you've gotten from them?
The general message is that they were just going to wait until the pooling is completed to make their decision of whether they participate or not.
And with respect to some of the owners of larger interests, such as Chevron, has Chevron taken a position in this matter?
No, their position is that they remain neutral.
And is that true for any of the other, for Marathon, for instance,
Yes, it is.
and for Concho
Yes,
and MRC Permian?
yes, that's correct.
So is it fair to say they're waiting to see how this plays out before they decide which way to go?
Yes, that's correct.
In the first page here that we were just looking at, this illustrates the ownership interest in Tract 1. Is that correct?
Yes, track 1, and as well as the other 3 tracks, but track 1's in.
And then the next page is tracks 2, 3, and 4. Is that right?
Yes.
And Pride's interest is in which tract?
Our interest is in track 3.
And that interest is 100% of the Wolf Camp rights in tract 3. Is that right?
That's correct.
And the ownership of the Bone Spring in tract 3 is owned by Coterra, correct?
That's correct.
And then here in your exhibit A3, is this your well proposal?
Yes, it is.
And this was the initial well proposal that went out in 2022, correct?
That's correct.
Pride first proposed this well almost 4 years ago, correct?
Yes, that's correct.
And since then, you've sent a couple of update letters, is that right?
Yes.
Can you describe to the division those update letters?
In one of the letters dated, I think it was December the 30th of 2025, we sent an updated AFE to the working interest owners, and then we've sent one in January of 2026, and we were updating the overhead rate within that letter.
Okay, and then I'm turning now, I believe, to PDF 27. Is this the revised AFE?
I can't see the bottom of it, but I can flip over here to it.
Ms. Shaheen, when you show something, would you say what exhibit number or letter it is?
Yes, this is still part of Exhibit A3.
Perfect, thank you.
Yes, that is the revised AFE.
And what is the total net cost for the revised AFE?
$9,345,780.
And have you compared this AFE to Coterra's AFEs?
Yes, we have.
And what is the difference in cost between the two AFEs?
The difference is like $1,369,853, where Coterra's AFE is larger than Pride's.
And what do you attribute that difference in cost to?
Appears that the majority of that extra cost is facility cost that Coterra has on their AFE.
And why is there such a difference in the facilities cost for these two wells?
Pride Energy has drilled and currently operates 6 wells in section 13 in that same section that we're talking about, section 12 and 13, but our wells are located in section 13. And we have an existing facility that is shared between all 6 wells. And so when we drill this Gulf State 401H well, then we would share the facility with the other 6 wells with this well. So it would be 7 wells that would be sharing that facility.
And not only will it be less cost, right? It's less use of the surface. Is that correct?
Oh, yes. We would not have the footprint anywhere near what Coterra would have when they're building a brand new facility. We would simply lay a flow line from our well over to the existing facility that we already have.
And what impact to the surface would that single flow line have?
It had very little impact. I mean, it would just basically be laying a flow line, be buried, and so it'd be very low impact to the surface.
And you've reviewed the testimony of of Coterra's witnesses, have you not?
Yes, I have.
And we do have a surrebuttal exhibit. I don't know if we want to go that far. But Mr. Pride would like to testify to a surrebuttal exhibit, and I'm thinking that might be more appropriate when we come back after those rebuttal exhibits offered by Coterra have been admitted.
Has the surrebuttal been admitted? The exhibit?
No, we just
okay.
prepared it overnight.
Okay. Then
Or this,
let's
actually, I believe we prepared it this morning.
let's deal with that at a later time.
Okay.
Let's just have him testify as to all the exhibits that have been admitted.
Okay, thank you.
So are you, okay, you're still going with your direct and your rebuttal?
Well, I'd just like to ask a couple of wrap-up questions.
Yes, of course.
Again, as I mentioned, it's hard for us to be complete in our rebuttal until we've heard Coterra's direct case. So I would reserve the right to bring Mr. Pride back if necessary. But Mr. Pride, you've reviewed the exhibits prepared by Coterra, is that correct?
That's correct.
At this time, do you have any other information that or response to any of Coterra's testimony other than what you've stated to date?
Well, it's Pride's view that we can drill not only better wells whereas we're developing the reservoir, and we can also drill the wells cheaper. And so you can get more oil and gas out of the ground for all the owners in the wells with Pride's operations, and we can drill the wells much cheaper, which will save all the working interest owners cost.
And do you know offhand how many wells Pride operates in New Mexico at this time?
We operate 35 producing wells in New Mexico.
And do you know how many of those are horizontal wells?
We have 16 of those are horizontal wells.
And how many do you operate in Lee County?
In Lee and Eddy County, we operate 28 producing horizontal wells.
And how long have you been operating those producing horizontal wells in New Mexico?
Oh, several years, probably 8 to 10 years. We operate more than 100 wells in various states.
I have no further questions of Mr. Pride at this time, but I do reserve the right to bring him back.
You don't have to say that anymore.
Okay.
You have the right to bring him back
Okay.
if you need to.
Thank you.
And so does Mr. Zimsky. Mr. Zimsky, do you have cross-examination for this witness?
Yes, I do.
Please go right ahead. And will you turn off your microphone so we don't get the feedback? Thank you.
Mr. Pride, good morning. My name is William Zimsky. I'm the attorney for Coterra Energy, and I have a number of questions for you. Just to follow up real quickly on what you just testified about, 35 producing wells, 16 of which are horizontal. How many of those did Pride actually drill as opposed to acquire after they were drilled and completed?
We drilled all of 16 horizontal wells. Pride Energy drilled all 16.
And how many of those wells had a lateral length greater than 8,000 feet?
Greater than 8,000 feet?
Yes.
We didn't have any greater than 8,000 feet. We've drilled some 3/4 of a mile, 7,500 feet, and others are about 1 mile laterals.
And how many wells of those wells we just discussed, the 16 horizontal wells, how many in the New Mexico, in Lee County and Eddy County had a lateral length of greater than 6,000? I think you might have mentioned there was one at 7,500, but is that the only one over 6,000?
No, we have 2 wells that we drilled about a mile and a half laterals. We utilize a Basin Engineering, our consulting company, on all of our drilling and all of our completions. And they've had well over 100 years combined experience in drilling hundreds of wells in this area. And they've worked for EOG and many other companies.
But Pride has supervisory control over them, don't they?
Yes.
And now Pride has not drilled any lateral lengths at the length proposed with the subject well, the 401H well, correct?
Pride Energy hasn't, but our consulting company has drilled hundreds of wells that length. And they're the ones that oversee the drilling operations and the completion operations of the wells.
So then you contract out with them. So your ability to manage risk involved in the drilling and completion of wells is outsourced?
We work very close with the personnel at Basin Engineering on a day-to-day basis. And so we work with them and they work with us, and as we drill and also as we complete the wells.
Now, I want to talk a little bit about the flow line. It's going to be 1 mile long, approximately from the well pad for the 401H to your shared facilities.
It'll be a little bit less than a mile. Well, based on where our facilities are, it'll be a little bit less than a mile.
And now I'm going to share your AFE on the screen. Can you show where in the AFE that you account for the cost of that flow line?
I can't see the whole. It's
exhibit A3 in PDF page, I believe 27. Or 28.
Yes, it's in the column noted as facilities cost. And which has a total of $729,000. And it's got a pipeline cost in there as well, but the total facilities cost we show 729,000. That includes land, the flow line.
And about the shared facilities, you were talking about there's 7 wells sharing. Is the working interest owners in the proposed 401H well, will they be sharing in 1/7 of the capital expenditures to construct that facility, or just 1/7 of the operating cost?
No, the total cost of the facility for those 6 existing wells were like $3.2 million. And so if we divide that by 7 wells, once we drill this well here, then the total cost of the facility would be $460,000 or so per well. So it would be prorated. The facility cost would be prorated. So for this particular well, it'd be $460,000 or so under the AFE amount that we allowed.
Now, on your facility cost, what is your facility cost again on your revised AFE?
Facility cost is $720,000.
And that includes the $474,000 on the shared facilities?
That's the total, yeah, that's the total facilities columns that's set out on the AFE.
So it's the 1 mile flow line plus the shared facilities?
Yes.
Now I want to talk about the wells, the neighboring wells, the Go State wells in east half of section 12 and 13. Now what's the lowest depth you drilled in those sections?
I don't recall the exact depth of the wells.
Excuse me, yeah, that's good, that's fair. What is the lowest formation or sand or target interval that you completed any of those wells?
We've drilled 6 wells, 2 in the first Bone Spring, 2 in the second Bone Spring, and 2 in the third Bone Spring in section 13.
And the 2 in the third Bone Spring would be the 305H and the 306H?
Yes.
And what was your ownership interest in those lands? How deep did Pride own a working interest? Was there any depth severance? In other words, did you own in the Upper Wolf Camp?
Those wells were not drilled to the Upper Wolf Camp. We own 100% working interest in each of those 6 wells.
But that's my question was, you didn't drill into the Upper Wolf Camp, but did you have the right to, in other words, were you a working interest owner in the Upper Wolf Camp for those lands?
Yes, we do own the Upper Wolf Camp or the Wolf Camp formation in the north half of section 13.
So in the current case, you don't own any interest in the third Bone Spring sand, correct?
In the current case, for the well that we're proposing to go State 401H in the drilling spacing unit, we do not. We own the Wolf Camp. We own the Wolf Camp, right?
And so since you don't own in the third Bone Spring sand, you didn't have the right to complete a well in the third Bone Spring sand, correct?
In which drilling?
In the current case, the west half of section 12.
Yes, that's correct. We own in the Wolf Camp.
So for the east half of section 12 in section 13, you had the right, you could have gone to the Upper Wolf Camp, but instead you chose to target the third Bone Spring sand. Is that correct?
Yes. The Wolfcamp was not, back, this had been many years ago when we drilled those wells. So at that time, the target prospect was the first, second, third Bone Spring, not the Wolfcamp when we drilled them about 6 or 7 years ago.
Weren't they completed in 2022?
Well, I mean, it might, I don't have it right here before me as to when the completion date was, but it's been several years ago.
And I think strike that, I'll move on. So regarding surface disturbance, you're aware that Coterra has been awarded operatorship of the first and second Bone Spring in the west half, section 12, correct?
Correct.
And are you aware that their pad will be built no matter who is awarded operatorship in this case?
I'm not sure what Coterra plans to do with the first and second Bone Spring if they're not operated, if they're not awarded operatorship of this in this case.
Well, let's go to your hearing exhibit, your statement, which I believe is Exhibit A.
Which page would that be?
It's on page 11 of the PDF, and we're sharing it on the screen.
All right.
Can you go to the next? It's page 3 of Exhibit A, page 13 of the PDF hearing packet.
All right.
And I want to draw your attention to paragraph 14.
Yes.
Are you there?
Yes.
And specifically the second paragraph or second sentence, however, anticipated production from the first and second Bone Spring wells does not justify drilling these wells with today's oil prices. Did I read that correctly?
Yes.
And what was the basis for you making this statement?
Well, you know, today's hearing doesn't pertain to the development or drilling of the first or second Bone Spring wells. While that's true, geologically, the first Bone Spring sand gets worse as it goes back to the west from the wells that's referred to in the rebuttal exhibits that you sent last night. And so geologically, it's first and second Bone Spring is not as near as good in the drilling spacing unit what we're talking about today as the wells back to the east. So we don't think at today's prices at $55 to $58 per barrel, we don't think it would be economically based on the AFE cost that Coterra has for drilling those first and second Bone Springs. We don't think that it makes sense to drill those. Again, today's hearing does not pertain to the first and second Bone Spring, but that's the logic behind my comment.
And again, like you earlier testified, you don't know what Coterra's plans are as far as locating their drill pad for these two wells, right? So you don't really know what their plans are. You're just merely speculating based upon your analysis as to what their intentions are. Is that correct?
Objection to his mischaracterization of Mr. Pride's testimony.
In what way did he mischaracterize it?
He's calling it speculation. And I don't believe that Mr. Pride is speculating. He's been in the business for decades, and he's aware of the economics of developing those wells. He has his own wells in the first and second Bone Spring. And so I don't believe that Mr. Pride's testimony is speculation.
Mr. Zemsky?
I didn't say his testimony about his analysis was speculation. I was saying he was speculating about Coterra's intention to drill these wells. There's a big distinction.
Ms. Shaheen, with that clarification, do you still object?
I believe Mr. Pride acknowledged that he doesn't know what Coterra intends to do if this application is not approved.
Mr. Zimsky, why don't you rephrase the question? I don't think it's fatal to your cross-examination to rephrase it, but let's take a quick 5-minute break at this time before you do that way. You can think about,
Thank you.
how you want to rephrase it. Thank you. We're off the record. Mr. Zimsky, are you ready to proceed? Mr. Court Reporter, are you ready to proceed? Yep, let me know. You ready? Okay, go right ahead, Mr. Zimsky. We're back on the record.
Yeah, Mr. Pride, coming back to. Yes, Mr. Pride, I'm going back to your statement, paragraph 14, the anticipated production does not justify drilling these wells at today's oil prices. Just to be clear, and to Ms. Shaheen's point, that's the opinion of you and Pride, but you're not testifying that Coterra is not going to drill those wells, correct?
No, I don't know what Coterra plans to do with the first and second Bone Spring wells. That comment is my opinion that when we drilled our first and second Bone Spring wells, it was $100 a barrel. At $55, in my opinion, it doesn't make sense to drill first and second Bone Springs at today's oil prices, which is around $55 to $58 a barrel.
But you didn't drill the wells thinking that oil was going to be $100 a barrel on a continuing basis, did you? I mean, you projected a lower return, but I'm just going to move on. Earlier, I'd asked you whether Pride had drilled any wells of the same length as the one being proposed by the 401H well, and you indicated you have outside third parties that did your drilling and they had drilled a lot of wells. So let me rephrase the question. Pride has never supervised a third-party driller in drilling a well at the same length as you're proposing here. Isn't that correct?
Yeah, we haven't supervised wells for Pride Energy to drill 2-mile laterals in this area. I'm just saying that Basin Engineering, our consulting company, has drilled hundreds of wells to 2 miles and longer, and have drilled that for multiple states, not just in Mexico. But
okay, but to answer my question, your answer to my question that Pride has never overseen the third party drilling a well at the length similar to the one proposing is no. Is that correct? And I just want a yes or no question or answer.
Yes.
You have not. Okay, that is correct. Okay, thank you. Now, you earlier testified that when you drilled those wells in the neighboring sections and lands where you targeted Third Bone Spring sand, is Pride have any plans to go and drill a well in the upper Wolf Camp formation?
You mean other than the current drilling spacing unit that we're talking about today?
Correct.
Not at this time.
Now, I want to talk about negotiations between you and Coterra. I don't want to get into any specifics. I just want to your general characterization of those negotiations. Do you believe that both parties negotiated in good faith?
Yes.
And now you indicated that, and Ms. Shaheen was talking about in her opening statement, there's been 4 years since the time that Pride filed its original application and this hearing date today. Are you blaming Coterra for 4 years of delay?
I'm just saying that we filed it in 2022, and 7 months later, Coterra files a pooling application, and it has been delayed for some over 3 years since Coterra filed their competing pooling.
And that delay was a combination of factors. There were a number of continuances where the parties, both parties filed for various continuances. They were all unopposed. Then we had the Wolf
Mr. Zimsky, are you testifying?
No.
Sounds like you are.
Well, it's a leading question to an expert. He can say no.
Okay,
Let me just, fair point. Let me just start again. Wouldn't you agree that there are a number of continuances filed after, and let's talk about the period, there was a delay between Pride filing its application and Coterra filing its application, correct?
Yes, there have been continuances.
Okay, well, my question is, since that, let's focus on the time since Coterra filed its application. Are you saying that Coterra delayed was the cause of delay of the proceedings? Or was it more the fact that both parties filed continuances, correct?
Both parties have filed continuances, if that's your question.
Yes, okay, and I just want you to acknowledge that. And the continuances were, if Pride filed a continuance, Coterra didn't object, and when Coterra filed a continuance, Pride didn't object. Is that correct?
Yes.
And there came a hearing where the OCD decided, based on testimony of Ms. Fry and your geologist at the time, that there was no frac baffle in the subject lands, and therefore they denied both applications, directing the parties to file applications to create the Wolfbone pool, correct?
That's correct.
That was the fault of neither party, correct?
Yes.
And didn't the parties actually end up filing a joint request, a joint application to create the Wolfbone pool?
I think that was the way it came about. It's been a while back, but
So in other words, Coterra and Pride have been working together. That was a bump in the road that caused some of the delay, correct?
yes,
And Coterra and Pride figuratively held hands, got together and filed a joint application to create the Wolfbone pool, correct?
we never held hands, but we filed it together.
Well, I said figuratively, so. That picture's now in my head, so I can't get it out. Now, and since that time, there have been a couple delays through no fault of anybody until we got to today. Would you agree with that?
Well, we filed our pooling and they waited. I don't know why they waited so long, but they waited for like 7 months before they filed their competing pooling, which created a delay, which is now turned into over 3.5, almost 4 years. So if they hadn't filed,
if they hadn't filed the complaint, you would have walked in and got the operatorship. So that's the delay you're complaining about?
Objection, argumentative.
What's the, Mr. Zimsky, I'm going to sustain the objection because it is argumentative. I don't understand where you're going with this line of questioning. It seems to me, let me just go back for a second. It seems to me that this witness has already said that the communication was in good faith. He seems to have acquiesced to that it was in good faith. So why do we need to get into this much detail here?
Well, Your Honor, I just don't want Pride to hang the 4-year delay on Coterra's head.
I think it's been clear. I think you've made it clear that it's not.
Okay.
So you've made your point. I just wonder how much more of this we need and whether it serves you or us. So why don't we move on from this line of
By
questioning?
telling me I made my point, I am glad
Yes.
to move on. Thank you. Mr. Hearing Examiner, if you could give me like just 2 minutes.
Sure.
I think I'm very close to being done. That's all the questions I have at this time for Mr. Pride. I appreciate your time.
Okay, now let's go to cross-examination from Mr. McClure.
Thank you, Mr. Hearing Examiner. Mr. Pride, on your breakout of ownership, I believe it's page 18 of 109 of your exhibit packet.
Yes.
You see on here where you have several persons listed as being included for curative purposes. Looks like it's Crown and Crump and
Yes.
Maverth. Can you please describe briefly, I guess, what you mean by for curative purposes?
Well, they showed up when checking ownership for this particular track, but they didn't actually own anything in there. The Crump Family Partnership Ltd. owns an interest, but Crump Energy Partners 2 LLC does not. But we named them because they showed up in title, not as an owner, but just kind of as strangers in title. And
what do you mean? What do you mean by they showed up in title, but not as interest owners?
For example, that there was an assignment that came into Crown Oil Partners 4 LP, but the party that was assigning into them, they didn't own any interest, that type of thing.
So you're not implying, or you're not stating like they have like an overriding royalty interest or something like that. You're saying they showed up as working interest owner, but the person that they got interest from didn't have an interest?
Yes. So that they were not a working interest owner per se, but they had an assignment into them. However, the assignor did not own any interest. So they don't actually own any operating rights.
Okay, so for each of these persons, it would be 0.0% interest for them then, is that correct?
That's correct.
Have you reviewed Coterra's landman exhibits?
Yes.
Are you in agreement with the interest breakout that they have?
Most of the interests are identical. There may be some of the very small interests might be slightly different, but predominantly they're really close.
Now, earlier you referenced that Crump signed an election with Pride for Pride's proposed well here. Is that correct?
Yes, that's correct. It was Crump Family Partnership Ltd. is the one who signed. That's the owner who actually owns an interest.
Did Crump also, or did Crump Family Partnership Ltd. Also sign a JOA with Pride?
No, they did not.
If the division force pools the interest for Pride in this case, do you feel that Pride would be able to drill the well within a year?
Yes.
Do you feel that Pride would be able to make any changes to the facility, build the facility, complete the wells and bring them online within a year following that?
Yes.
Earlier, Mr. Zimsky brought up some wells that Pride completed in the Bone Spring 3 in approximately 2022. Do you remember that?
Yes.
Which wells was Mr. Zimsky referring to?
He was referring to the Gulf State wells, it's 305 and 306H wells. That's the third Bone Spring wells, but we also drilled 2 in the first Bone Springs and 2 in the second Bone Spring in section 13.
Okay, so then that is within 1 mile of this proposed area, is that correct?
Yes.
Is it accurate to say that the proposed last take point for the well in this unit should be in section 12 rather than section 19?
Yes, it should be in section 12.
Let me look at one more thing. Mr. Pratt, if I refer to the new Form C-102 rather than the old Form C-102, do you know what I'm talking about?
Which one are you referring to? The which page in the?
What I'm referring to is the division, like a year or 2 ago, something like that. We came out with a new version of Form C-102. It's a different version than the Form C-102 prior to that. Do you know what I'm referring to?
Yes.
Okay, so thank you, Mr. Pride. Thank you, Mr. Hearing Examiner. I have no further questions at this time.
Thank you. Ms. Shaheen, any redirect?
No.
Thank you. Mr. Pride, thank you for your testimony. You're excused, although you may be recalled at a later time.
All right, thank you.
Thank you. Okay, Ms. Shaheen, your next witness.
Thank you. That is Mr. Harvin Broughton.
Thank you. Mr. Broughton, it would be helpful if you turn your camera on.
It's on.
Ah, there we go. It is now.
Okay.
Okay. I remind you, you're under oath. Would you please tell us what is the area of expertise you've been previously qualified by this division?
Petroleum geology.
Perfect. Thank you, Ms. Shaheen.
Thank you.
Which exhibits come in under this witness? B?
This is Exhibit B
I
and
thought
the
so.
sub-exhibits.
Okay, and they're all admitted, so thank you.
And I'm going to share. Mr. Broughton, let's walk through each of your exhibits.
Okay.
Turning to Exhibit B1. And that is page 47 of 109. If I can get there a little more quickly. Can you describe this exhibit for the division?
Yes, this is a map of the greater Permian Basin with the approximate location of the Gulf State 401H depicted as a star in the western part of Lee County there.
And there's nothing special here. This is the ordinary general location map that we provide in all of our hearings. Is that right?
That is correct. Yes, it's just an overview of the Permian Basin and with the location depicted.
And turning to Exhibit B2, can you describe to the hearing examiners what you've depicted here?
Yes, this is I'm calling a sub-regional structure map on the top of the Wolfcamp A formation. It's got a contour interval of 50. And so it's showing the general attitude of the Wolfcamp top in the subsurface. And I'm calling it dipping slightly down to the south-southwest. It also shows the horizontal spacing unit in the red box there in section 12 and 13. And then it shows a reference line for a cross section that you're going to see shortly, A to A prime, a south to north cross section involving 3 wells that penetrate this interval.
And turning to the cross section that you mentioned, Exhibit B3.
Yes, this is a stratigraphic cross section showing the top from the top of the Third Bone Spring sand down slightly past the base of the Wolfcamp A interval. It's actually flattened on the top of the Wolfcamp A, or the top of the Wolfcamp. And then it shows the top of the Third Bone Spring, top of the Wolfcamp, top of the base of the Wolfcamp A. And this is A prime cross section as depicted in the previous reference slide.
And so the red line where it says top Wolfcamp A, that's the top of the Wolfcamp A. Is that where the depth severance exists?
That is, in fact, where the depth severance exists, yes.
And so from here, the green line, top of the Third Bone Spring, down to base of the Wolfcamp A, the green line to the blue line. Between the blue line and the green line, is that what's now been designated the Wolfbone Pool?
Correct. That is the newly formed Sharb Wolfcamp or Wolfbone Pool. Sorry.
And for the laypersons among us, can you just tell us what each column in your in these 3 well logs reflects?
Okay. So the column on the left is the gamma ray curve on all 3 wells. On the middle, there's a depth track there. I think you can see the numbers in there. Just to the right of that, on each of the 3 is a resistivity track. It's showing the resistivity of the formation as measured by wireline logging equipment. And then the column on the right of each 3 is the porosity. So those are curves created by the porosity logs during the wireline logging process.
And on going back to the Exhibit B2, I believe you have the map showing A to A prime where these wells are located. Is that right?
That is correct, yes.
And so here you've got a little circle with a plus sign, and then to the southeast you have a similar icon. And here, which wells are we looking at, and what does each of these icons represent?
Okay, that just represents the cross section. So the well to the southwest in section 23, that's the first well in the cross section. The middle well in the cross section is at the southeast corner of section 13, and then the last well, or the third well in the cross section, is the northern well up there in section 2. So this cross section runs from south to north.
All right. So when it says A here, this icon, which well is that?
That is the Government 23 number 1.
And about how far is that well from the proposed spacing unit?
Oh, less than a half a mile.
Same thing with the second icon. Which well is that?
That is the Super Cobra State 1H, and that's 3/4 of a mile.
And is there something significant about the Super Cobra? Is it,
Well,
is that the?
Yeah,
I'm sorry,
I anchored my presentation around that well because that's the well that's used in the order that creates the new Wolfbone Pool. So I thought it'd be prudent to use that well at least include that well in anything that I presented here. And that'll be my type log well that you'll see coming up in some additional slides. I've used that well just because it's the one referenced by the OCD in the order creating the pool.
And all of these wells have logs that go down into the Wolfcamp A, is that right?
Yes, I mean past the Wolfcamp A actually, but yes.
And then the A prime well, which well is that?
That is the New Mexico State number 3.
And it looks to be how far from the spacing unit?
It would be maybe a little over a half a mile northeast of the toe of the well, the toe of the 401H well.
So scrolling back down now, is there anything else that you think is important to note in your Exhibit B3 here, your cross section?
Not at this point, no.
Turning now to Exhibit B4, and that is page 50. Can you describe to the hearing examiners what we have here?
Yes, so this is an expanded view of the Super Cobra 1H type log well that we'd referenced previously. And again, it shows the same thing, shows the top of the Third Bone Spring Sand, the top of the Wolfcamp, and the base of the Wolfcamp A. I've also depicted on there the approximate landing depth, planned landing depth of the Ghost State 401H. And then the map on the right is just simply an expanded reference map of where that type log well, the Super Cobra, is in relation to the subject lands that we're talking about.
Anything else that's noteworthy here at this time?
No, not necessarily, no.
Turning now to the next
Oh,
exhibit.
well, wait, let me back up. I've also defined the scarred pool there. It's over on the right. So that just shows the graphic of the pool from the top of the Third Bone Spring Sand to the Wolfcamp A base. So sorry about that.
Thank you. Turning now to what I believe is Exhibit B5. Can you please provide a description of this slide to the hearing examiners?
Okay. So this is a wellbore profile and gun barrel view depicted alongside the type log. So on the left column, I've attempted to show the trajectory of the wellbore and attitude and approximate landing depth with the footages. In the gun barrel view, if you're looking from south to north at that west half, that's where that well would fall. So I've got it at the approximate depth, and if you can follow that over to the type log, and that would be the target interval for the 401H. And again, over on the right, I've got the layout of the tops and the definition of the pool.
And finally, your Exhibit B6.
Okay, so this is a gross wolf bone isopac map. So what I've done here is create an isopac map that defines the pool. So it's from the top of the Third Bone Spring Sand to the base of the Wolfcamp A. And again, on there, I've got the horizontal spacing unit, and you can see in the southeast corner of section 13 where the type log is. You can see that, the little red plus sign, and then you can see the approximate thickness or the map thickness of that entire unit across this horizontal spacing unit.
Now, have you reviewed the geology exhibits and testimony of Coterra's witness? I believe it's Ms. Fry.
I have, yes.
And I'm going to turn to those exhibits now. Give me a minute here to stop sharing and then reshare. So I'm going to take us to Exhibit B4. I believe it's page 71.
Okay, I'm there.
Okay, I'm not there yet, but give me a minute. I'll get there. Let's see. And now I'm going to share. All right, can everybody see that?
I can, yes.
So you've reviewed these exhibits, correct?
I have, yes.
And is it your understanding that Coterra plans to land its well here where my hand is, and that is in between the two wells, Bone Spring wells that Coterra currently operates, the Quail 11 State 1H and the TL12 State Com 2H?
Yes, that's my understanding, is they plan to land at that depth.
And then turning now to the next exhibit, what is your understanding of what's depicted here in what I believe is Exhibit B5?
Okay, well, they're showing the Pride 401 Go State Com 401H, and its landing depth at a slightly deeper depth than their 301H proposal.
And is there anything notable here about Exhibit B5?
Well, they're showing a bunch of the Go State wells. One thing I noticed is that there was no first or second Bone Spring wells here as there is in the previous slide. The Showbiz 101H and 201H are absent. I was curious why that might be.
Okay, so it's they reflect the Showbiz wells that are proposed on the previous exhibit. Is that right?
That is correct. Yes, they show all three of their Showbiz wells, but then in this slide, there's only the Go State 401H, which is the proposed Pride well.
Okay, and all three, I think everyone's aware of this, but just to be clear, all three of Coterra's Showbiz wells are in the Bone Spring formation. Is that right?
Yeah, they're all in different Bone Spring sand units. Yes.
Okay, and the proposed well here that we have by Pride is in the Wolf Camp A. Is that right?
Right. It lands in the upper part of the Wolf Camp A. Correct.
Okay. I don't have any further questions for Mr. Broughton at this time.
Thank you, Ms. Shaheen. Mr. Zimsky?
No questions.
Thank you. Mr. McClure?
Mr. Hearing Examiner, I do have a quick question for Mr. Broughton.
Right ahead.
Mr. Broughton, does the third Bone Spring and the upper Wolf Camp differ across section 13?
Well, are you referring to a particular slide?
I'm asking a general question, I guess. Let me re-ask it.
Okay.
Across section 13, is the Wolf Camp A and the Bone Spring 3 relatively similar?
In terms of what? I mean, are you in terms of thickness? No, they're not. In terms of porosity, you could say that they were. In terms of resistivity, they look very similar. The sand packages at the top of the Wolf Camp A look relatively similar to that of the third Bone Spring sand. Yet yet they are thinner. It's just the top couple of 100 feet of the Wolfcamp A that are the productive sand interval.
Is there enough difference across section 13 that would warrant completing the wells differently?
That would be more of a completion engineer question, but as a geologist, you know, with my working knowledge as a geologist, I would say, you know, I would say probably not. The deeper you would land, you'd need to probably increase, you know, the volume of your frac, you know, to accommodate going up across the entire Third Bone Spring sand. But other than that, I wouldn't think that that there'd be any difference.
Okay, thank you, Mr. Broughton. No further questions at this time, Mr. Hearing Examiner.
Ms. Shaheen, did that raise any redirect for you?
Not for me as a layperson.
Thank you. All right. Thank you, sir. We appreciate your testimony, and you may be recalled. I don't know.
Okay.
But you are excused for now. Okay, Ms.
Thank you.
Shaheen, your last witness.
Thank you. That is Mr. Gifford.
Good morning again, Mr. Gifford. I remind you, you're under oath. Go right ahead, Ms. Shaheen.
Thank you. Give me a minute to reshare. And turning now to Exhibit C, which is page 76. Oh, wait, am I looking at the right ones? No. Exhibit C, page 54. And Mr. Gifford, the core of your testimony here is in your paragraph 5. Is that correct?
That is correct.
And can you explain your opinion stated in paragraph 5?
Sure. So my opinion of whether the well should be landed in the Wolfcamp versus the Third Bone Spring, I'm making the argument that the well should be landed in the Wolfcamp because it is general industry knowledge within the oil industry that fracs are going to grow out or up and less so down. And so with that being said, Pride Energy believes that the completion or the fractures that we create in our wellbore where we plan to land our wellbore, we will capture the Third Bone Spring sand reserves. And if you check out Exhibit C1, which was taken from a previous Coterra slide, they essentially agree with what I'm saying there. So I just want to establish that. So they say landing in the very top of the Wolfcamp sand depletes Third Bone Spring sand. And they also stated Pride will produce and sell large amounts of reserves from the third sand. So I just wanted to note that Coterra and Pride are in agreement that the location of Pride's proposed well will deplete the Third Bone Spring sand, and we will sell large amounts of reserves from the Third Bone Spring sand. And so with my testimony, I'm arguing that you're likely to see a higher EUR placing a well where we're proposing to place the well in the upper Wolfcamp, because the way we see it is that we're going to capture the total reserves of the Third Bone Spring as well as the reserves of the Wolfcamp. And so what you see based on EUR, it's additive. If you want to talk about performance, that's a separate issue, but I do believe that the performance would be fairly similar. But but the Wolf Camp gives you an upside there where the Third Bone Spring sand is going to be produced by both Coterra's well and Pride's well, but Pride has the ability to access the Wolf Camp, which provides the upside. And the other thing I wanted to mention was that Pride's AFE, and this has been mentioned before during Matt's testimony, but Pride's AFE is approximately 1.4 million lower than Coterra's AFE. And so if you're looking at capital efficiency, our well will cost less to drill, and therefore that's going to help the economics of the well. So from a cost input standpoint, we believe our well stands to benefit from lower cost, and we've established that's primarily due to lower facility costs due to an existing facility that Pride has. And then we also believe that the performance of our well will be similar to, if not better than Coterra's well, due to the upside in the Wolf Camp. And therefore, we believe that the superior place to land the lateral is Pride's proposed Wolf Camp.
You got a little bit ahead of me there. So I want to back up. You mentioned the acronym well, it's not really an acronym, but initial EUR. Can you explain to the examiners what EUR stands for and us lay people?
EUR stands for Estimated Ultimate Recovery. And so that's, generally speaking, what you're going to recover from the wellbore that you drill and complete and produce. Yes, so simply said, that's what it is.
Okay, and then one more clarification for the record. This was actually an exhibit in the previous hearing on these two wells before the Wolf Bone pool was created. Is that right?
That is my understanding, yes.
And so it's exhibit C1 in this proceeding, but it was I believe exhibit C5 in the previous proceeding. That's just to clarify the record. And then I may have missed it. You may have explained this, but you just talked about why you believe Pride's well is likely to recover more, including much of the Bone Spring. And why do you believe that Pride's well will produce as much, if not more, than Coterra's proposed well?
So I believe that because I think it's very safe to assume that everyone here agrees that our well's fractures would grow up into the Third Bone Spring sand, thereby depleting the reserves of the Third Bone Spring. What is not likely to happen is for Coterra's proposed wellbore within only the Third Bone Spring to have their fractures grow low enough to capture the reserves within the Wolf Camp, which is where we propose to put the lateral. So that is why you see that additive between the Wolf Camp and the Third Bone Spring, whereas with Coterra's proposed well, you only have the Third Bone Spring reserves.
And so you did start testifying about your rebuttal to the reservoir engineering statement offered by Mr. Weinkauf. So you have reviewed that written testimony and the related exhibits, is that right?
Yes.
And do you recall Mr. Weinkauf's comments in his paragraph 9? We can turn to that now. And that is page 80. Or maybe not. Page 78. In particular, he states here that to Coterra's knowledge, Pride has less than 10 wells producing within Lee and Eddy counties. Do you recall reviewing this testimony?
I do recall reviewing this testimony.
And what is your response to Mr. Weinkauf's statement here?
Well, Mr. Weinkauf's statement here has been rebutted earlier, actually, in Matt's testimony, where he mentioned that we have 35 wells producing Lee and Eddy counties. So that's just not true. I'm not really sure where that information came from because it's factually not true. And then the second thing to note, just below that, he mentioned that all wells appear to be below 6,000 feet of lateral length that have been drilled by Pride Energy. And that is not true. Also, as noted during Matt's testimony, we have drilled wells of 7,500 feet of lateral length, 2 of those wells.
And Mr. Weinkauf also suggests that Coterra has more experience, doesn't he?
Yes.
And what is your response to that?
Well, I'd say the same thing that Matt said. So I'd say in terms of drilling and completions, I do not think that Coterra has more experience because of who we bring in to partner with in basin engineering. And as Matt said, they have, 100, if not more, years of experience combined amongst their personnel at their firm. And they're very good at what they do. And they've drilled many, many wells. And as far as performance is concerned, I would say that Pride Energy has seen, on average, for our sweet wells drilled, our horizontal sweet wells that we've drilled in New Mexico, we've seen greater than 100% rate of return on average across those projects, and we've also been at or below AFE on those projects. And that would include all of those wells that we've drilled, horizontal wells on the AFE side. So with that being said, Pride Energy is capable, in my opinion, to drill these wells, to have low costs and to have good performance.
And Mr. Pride testified earlier about how long Pride has been in business. Are you aware of how long Coterra or its parent companies have been in business?
It is my understanding that Coterra was a merger. I believe the merger was in 2021. And I believe the 2 companies that formed Coterra's merger, I believe it was Cimarex and Cabot. My understanding is that both of those companies are younger than Pride Energy. So Pride Energy has been in business, as Matt mentioned, for 45 years nearly, which is longer than the parent companies of both of Coterra's, the parent companies of Coterra.
Mr. Weinkauf also suggests that Coterra's development will be less costly because Coterra is already planning to drill and has received a pooling order for the Showbiz 101 and 202H. Do you recall that testimony?
Yes, I do.
And what is your response to that testimony?
Could you repeat the first part of what you said?
Yes, and I'll turn to the paragraphs. I believe this is paragraphs 10 through 12. And again, these are, excuse me. I'm moving too quickly here. These are paragraphs that we have challenged. So I don't know, Mr. Hearing Examiner, if you would prefer that I bring Mr. Gifford back to rebut this, or if you want us to just go ahead and do it now.
Wait, I'm confused. Repeat what you're asking me.
The objections that I made earlier
Yes.
with respect to Exhibit C
Yes.
encompass these paragraphs. And so,
In other words, the testimony of your witness is going to evidence that is not in the record that you have objected to. Yes, I don't want to discuss that now
Okay.
until we decide whether we're going to admit C paragraphs 9 through 13, C1 through C5. Specifically, what does this this testimony that you were about to get into, which of the objected to evidence does this go to?
well, actually, now that I think about it, I think we're okay with the paragraph 10.
Okay.
We had some issues with paragraph 9, and of course, Mr. Gifford just addressed that to correct the incorrect statements that are in paragraph 9
Paragraph 9 of what? Let's be specific.
of Coterra's Exhibit C.
Perfect. So now you're dealing with 10.
Now we're dealing with 10.
But you have not admitted paragraphs, or you have objected to paragraphs 9 and 10.
That's right.
So
9.
either really we shouldn't be discussing this at all. Do we need to strike something from the record?
Well, primarily what Mr. Gifford just testified about is an elaboration of what Mr. Pride already testified about. So I don't think it's necessary to strike that.
Well, we'll find out from Mr. Zimke if he feels the same way. But
Okay.
let's not go any further into any of the stricken evidence.
Okay, so then we'll move directly to paragraph 14 because I don't think
So, Mr. Zimsky, let's deal with this now. There was a question and an answer that Ms. Shaheen just clarified, and how do you feel about it?
I think with the paragraphs that she has objected to, I think all that's testimony should be stricken. And they can come back on rebuttal after Mr. Weinkauf testifies if you allow that in.
The problem is I don't know where that started. Do you know where it started? Because I need to tell the court reporter what to strike.
I think the corrections regarding some of the factual matters in paragraph 10, which we were going to address during our direct, obviously, we had realized that was a mistake, but yeah, so anything to dealing with paragraph 9 of Exhibit C.
And what does paragraph 9 talk about, Mr. Zimsky? What's the general subject matter without reading it?
It talks about the difference between the experience of Coterra
Yes.
versus the experience of Pride
Okay.
in how many, all the laterals that Coterra's drilled just in this year,
And what about paragraph 10?
That one.
Ms. Shaheen, while Mr. Zimsky's looking at paragraph 10 of the Exhibit C, what I'm wondering is, I mean, in all fairness, I think you've waived an objection to paragraph 9. Because you've asked questions to your witness about paragraph 9. You did it on your own. And so I'm going to allow paragraph 9 in. So Mr. Zimsky, we're really only talking about 10 through 13 now in Exhibit C. Have any questions been asked about any of that information to this witness?
I think she asked some questions about paragraph 10, Exhibit C2.
Did we get an answer though, or was it just a question without an answer? Because I think she stopped. I'm not saying that she stopped before she got an answer. I just heard her ask a question and then say, well, maybe I shouldn't ask about that.
Well, I think we can let that stand. Well, I mean, we're going to address it on direct.
Fine.
I mean, we're going to.
So Mr. Zimke, your paragraph 9 in Exhibit C is admitted. So now what we don't have admitted, Mr. Court Reporter, paragraphs 10 through 13 in Exhibit C and C1 through C5. They are still not admitted. And those are Coterra's exhibits. All right. So Ms. Shaheen, we've avoided any further problems. Do you want to continue your examination?
I do want to go to paragraph 14, but I would also note that if I've waived my objection to paragraph 9,
Yes.
I believe I've probably waived my objection to Coterra Exhibit C1.
Okay, and that
to be
makes sense.
Fair.
In all fairness. So I'm ruling that C1 does come in. Coterra C1 comes in. Okay, so why don't you proceed, Ms. Shaheen, and thanks for your frankness.
Thank you. So turning to paragraph 14, which I do not believe I objected to.
You did not.
Okay. Have you reviewed paragraph 14, Mr. Gifford?
Yes, I have.
And what do you understand Mr. Weinkauf to be stating here?
Just familiarizing myself with the paragraph. So this paragraph appears to be saying that offset production in the Third Bone Spring sand is superior to the upper wolf camp. And that I believe he does mention that they're, let's see. Yeah, he's saying that the third Bone Spring sand, yeah, he's saying that that's the chosen target of the wells nearby, and he's stating that Pride developed the third Bone Spring sand at the Go State. So,
And what is your response to that testimony?
that I don't really have any response to that specifically. I think it's just a fair point that the third Bone Spring sand has been developed in the area. I think probably the only thing that I would say is that due to the fact that the third Bone Spring sand has been produced in the area, uh, that is likely going to mean that if Coterra drills the well that they're planning to drill and they frack it, there is going to be somewhat of pressure depletion in that area, and that is strongly going to mean that their frac is not going to grow down because it's going to want to go out to that pressure depletion. So that would just state that there is that pressure sink in that area. There is that depletion in that area. Their frac likely will not go down. Therefore, they would not capture the Wolfcamp reserves, in my opinion.
Same question with respect to paragraph 15. And I apologize because when I read it as a layperson, I'm not sure I understand what he's saying. So can you also explain to the hearing examiners and us lay people what Mr. Weinkoff is saying here in paragraph 15?
Ms. Shaheen, I don't think that's proper for the witness to say what another witness is saying. He can provide his expert opinion about whether it's valid or not, but I don't think he's in a position to tell Mr. McClure and I what he is saying. So would you rephrase your question in
Sure.
that respect?
Sure. Let me ask you this. Do you have a response to the testimony in paragraph 15?
I do. I think Mr. Weinkoff in this paragraph, one of the main takeaway points that I have here is bringing up that the technical discussion should center on identifying the landing zone that can efficiently deliver wolf bone oil volumes to stakeholders. And due to my previous testimony stating that we believe that the frac will grow up out of the wolf camp and into the third Bone Spring, we believe that we're in the position to do that. We believe we will be able to have a superior well. We'll deplete the third Bone Spring and produce the third Bone Spring as well as the wolf camp.
Is there anything else that you think is important to say about in rebuttal to Mr. Weinkoff's testimony, with the exception of paragraphs 10, 11, 12, and 13?
Yes, I would say that there, and I can't point to, I would have to go through to find the very specifics, but I know it's mentioned multiple times throughout Mr. Weinkoff's testimony that he mentions cost savings, that the working interest owners will experience cost savings due to the 3-well development. But I guess the way I see this, that we're talking about who should drill this specific well and not a 3-well development. And so if we look at this specific well, Pride Energy has a lower AFE, as we've already stated, due to the facility already being built at the Go State. And therefore, the cost savings, well, there should be cost savings if Pride drills the well rather than if Coterra drills the well.
Thank you, Mr. Gifford. At this time, I have no additional questions for Mr. Gifford.
Mr. Zimsky?
Yes, good morning, Mr. Gifford. William Zimsky on behalf of Coterra. I have a few questions. Oh, real quick, you were talking about how old you were comparing the length of the two companies involved. And were you aware that Coterra, one of the merger partners, was Cabot Oil and Gas?
I believe so.
And they've been around since the 1800s. You're aware of that, right?
Was that Cabot specifically or Cabot's
Cabot
predecessors?
entity.
A Cabot
Well,
entity?
yeah, tracing back, the predecessor has been around since in the 1800s.
Okay, no, I was not aware of that, but
Okay.
the Cabot that I was referring to, I was not aware of that. Their
Okay,
predecessor.
let's talk about capital efficiency. You emphasized the delta, the $1.4 million difference in the AFEs. And if that number is indeed correct, and the Coterra owns 41.25% working interest, correct?
I do not have the interest right in front of
Well,
me, but
I'll just represent that to you, since we're talking about, you brought up the capital efficiencies. So Coterra would pay about $577,000 worth of that $1.4 million. And whereas Pride would only pay, they only own 12.5%.
Objection, Mr. Zimsky is testifying.
Mr. Zimsky.
I'm just
is this
setting,
data.
I'm just setting the facts to ask him a question.
Well, hold on a second. Yes, but are you assuming facts that are not in evidence?
I'm multiplying his number of $1.5 million difference by the ownership interest testified to by Mr. Pride
Okay,
of 41 point,
percent. I remember, yes.
yeah, versus 12.5%.
Okay,
So then I'm saying, okay, we have a difference of $1.4 million.
okay,
Who's going to bear most or a big chunk of
okay.
that?
So you're using facts and evidence
Correct.
to come up with this question.
Yes.
Okay, so machine, they're facts and evidence, so I overrule the objection.
It
ahead.
seems to me he should have his witness do the math and have that in evidence. I mean, it just seems a little odd for him to be doing the math and then asking my witness to do the math to make sure. And frankly, I was confused about what he was talking about.
Okay, I understand that. I understand the point. And I too was confused as well. There's another way of doing this. Why don't you just ask this witness to do the math that you are doing yourself and then let him come to whatever answer any question you have for him.
Okay. Mr. Gifford, as a petroleum engineer, I assume
Exactly.
you know how to do a multiplication table. If I can do it, but let's talk about that $1.4 million difference. Now, the testimony is that Coterra owns 41.25% working interest. Can you calculate how much of that $1.4 million that Coterra would bear as the working interest owner?
the 1.4 million in savings.
No, the $1.4 million difference. So if
Right.
if Coterra was awarded operatorship and there was their AFEs turns out, and these are estimates, obviously, and they, no one's, bound by them. They can be higher or lower. And you agree with that, correct? With AFEs?
That you're not legally bound to them? Is that the question?
Yeah, yes, that things happen and
Oh,
correct?
well, yes, correct.
Okay. Now, currently is proposed, there's a difference of Coterra's is, $1.4 million more, according to Pride's testimony. So if Coterra owns 41.25% of that, how much of the $1.4 million difference would Coterra have to bear?
So you're saying if Coterra drills the well?
Yes.
So you're saying if Coterra drills the well, how much of the 1.4 million would they have to bear? You would take their
Correct.
working interest and multiply that by the additional cost.
Correct.
Right.
Are you doing that?
Oh, are you asking me to get a calculator and do it, or?
Yes, I am.
Oh,
They
okay.
evidently don't trust my math.
I see.
I'm not offended.
And could you tell me the percentage again so I get that right here?
41.25%.
I'm calculating 577,500.
Now let's do that same exercise with Pride's 12.5% working interest.
What did you say the interest was?
12.5%.
I calculate 175,000.
Okay, that's what I got. Now, one last calculation. So how much, if you were comparing, for every dollar that Coterra has to spend on this $1.4 million, how many dollars, for every dollar that Pride has to spend out of the $175,000, for every dollar they have to spend to cover that cost, how much does Coterra have to spend?
It would be, I would think, somewhere between 3 and 4 times what Pride would have to pay.
Okay. Now you can understand why Coterra would want to be the operator of this well when it is bearing 41.25% of the cost. And while Pride is only responsible for 12.5% of the cost.
Yes.
Now let's talk about fracking. Now you say that aren't there some ghost state offset wells to the proposed 401 H well?
Yes.
Isn't that going to also cause some depletion pressures that you talked about that Coterra was going to experience?
Yes, I imagine it would.
And so you said Coterra's fractures aren't, well, maybe I misunderstood. Are, under Coterra's proposal, will their fractures go down? Will they go down at all or not at all or just go up?
Well, I can't say for sure, but I would think that they likely will not go down. And I think that the majority of their fractures will go out and up. The vast majority.
But as a reservoir engineer, that's just your estimate. You can't, there's no real hard science to, or to take, I scratch that. So why would, in the 401 H well was 100 feet below the Showbiz 301 H well, correct, in depth?
I believe that's correct, yes.
So why would, so why are how's the 401 H fracs going to go down to capture the Wolfbone if the Showbiz 301 H fracs aren't going to go down? There's no frac baffle.
I'm not claiming that Pride Energy's fractures are going to go down.
Oh, so you, oh, okay. And to recover from the third Bone Spring sand on any well, any horizontal well, isn't it a function of frac fluid pressure volumes?
I'm sorry, what was the question?
Isn't the amount of modern completions of horizontal wells or whether it's considered modern completions have a higher frac volume, more pressure than vintage wells, correct?
Yes.
And they did that because they realized that the more frac pressure volume that they applied to the horizontal fractures, the better the fractures were, correct?
That's correct.
And there is a frac baffle between the base of the second bone spring and the top of the third bone spring sand, correct?
When you say frac baffle, can you clarify what you mean by baffle?
A carbonate layer which would reject or really minimize any type of fracture emanating from the third bone spring to emanate into the second bone spring, correct?
Oh, I'm not knowledgeable about. I think that would be a good question for Harbin in geology. But
Okay, well, let's assume that's okay.
Mr. Zimsky, can you let him finish the answer? Because we have a court reporter who's trying to gather everything.
Apologize.
And I want the witness to finish. Mr. Gifford, please finish the answer before Mr. Gifford goes on. Before Mr. Zimsky goes on.
Okay. So, but I also don't, I guess I don't understand how it would be relevant to discuss above the third bone spring.
So, Mr. Gifford, it's not
what is
your
the question for me?
Mr. Gifford, it's not your role to question the relevance of a question. That's for that's for Ms. Shaheen to do. If she hears a question that's not relevant or she has an objection to it, she'll make it. Once the question's asked and if there's no objection, you answer it to the best of your ability. And if you don't know the answer, say you don't know.
Okay, I will do
so. Please finish the answer to the question.
I do not have an answer for that question.
Mr. Zimsky?
Okay, let's assume that there is what we'll call a frac baffle. Are you familiar with that term?
I am based on your explanation.
Okay, and there is no frac baffle between the third bone spring sand and the Wolf Camp, upper Wolf Camp. Is that your understanding?
That is my understanding.
And that's ergo we're here with the Wolf Bone Pool, since it's been declared to be a common source of supply. Do you agree?
Yes.
Okay, so it's a common source of supply. So when Pride fracks its well, it's not, the fractures will not meet any resistance as they move up towards into the third bone spring sand, correct?
Correct.
Did you say yes?
I said correct.
Okay. Now, let's assume there is a frac baffle, a carbonate layer, I think it's called, which will sort of arrest any further fracking into the second bone spring sand. There may be a little bit, but it's basically going to be contained by that frac baffle between the base of the second bone spring and the top of the third bone spring. Let's just assume that. I know you're not a geologist, but let's assume that for the purpose of this question. Okay?
Okay.
So if the Coterra's third bone spring well, the 301 Showbiz 301H, that will drain the third bone spring sand, or it not completely drain, can't completely drain it, but its fractures will go up to that carbonate base level, right? Between the frac baffle, the top of the third bone spring sand.
Yes, likely so.
Okay. Now, do you know what with frac volumes that Coterra is going to propose is going to use for their 301H well?
I do not know what they're going to propose.
And
Or
that's a big factor in determining how much of the frac, how big the fracs are going to be, how long they extend, and what directions they extend, correct?
Yes,
So you don't know what you just admitted you don't know what their frac volumes and pressures are going to be. So how can you say that their well is not going to recover as much as Pride's well?
because I'm stating that their well is going to recover the Third Bone Spring, and I do not believe it will grow. Their fractures will grow down to be able to capture any Wolfcamp reserves, and I believe that Pride Energy will recover the Wolfcamp reserves where we are landing the lateral, and it will grow up into the Third Bone Spring, thereby capturing reserves from the Wolfcamp as well as the Third Bone Spring.
So the difference, and you said the Pride well will not grow, the fracs will not grow down. Did you say that?
I do not believe they will significantly grow down, no.
Okay, and so your well is 100 feet below the vertical depth of the Showbiz 301 H well, correct?
Objection. I believe that misstates the evidence and record.
So Mr. Gifford, when you hear an objection, please wait. In what way?
If I understood Mr. Zimsky correctly, he stated that the difference in depths was 100 feet, and I don't believe that's correct.
Mr. Zimsky?
I thought I asked Mr. Gifford earlier if that was correct, and he said yes. And I could be wrong. My memory,
I thought you asked whether there was 300 feet difference. And I think he agreed to that, but not 100 feet difference.
Okay, I can ask the court reporter, but I can also just ask Mr. Gifford. Mr. Gifford, do you understand the contention here?
Yes, but now I'm confused because I don't know exactly, I don't recall what specifically he was asking.
Wait, when you say what he was asking, do you mean the last question he just asked you?
Yes, and whether it was different than the first question he asked me.
Mr. Zimke, what question did you just ask?
is there a different, do you know what the difference in the depths of the Showbiz 301 well versus the Pride 401 H well?
Not off the top of my head.
Okay.
Does that
helps
your
me?
Question?
Yeah, well, it helps me reframe the question.
So then basically I sustain the objection because the question, the way it was asked previously was misleading, but now you've asked a better question and he's answered you.
Okay.
Okay, so please-
And now I have another question.
Okay, we'll go right ahead.
So whatever the depth difference is, what you're saying is Pride will be able to capture, and let's assume it's 100 feet. Okay, just for the sake of this question, just for illustration. If it's 100 feet difference, what you're saying, Pride will capture that extra 100 feet that is above their wellbore and then capture the Third Bone Spring sand.
Correct.
But you cannot say whether Pride's well will recover more of the Third Bone Spring sand than Coterra's well, because you admitted that you don't know what frac volumes and pressures they're going to use. And you also acknowledged that that is a very important factor when determining the behavior of fracs in the ultimate recovery of a horizontal well. Correct?
Objection to the form of that question. Misleading, ambiguous, confusing.
Mrs. Zemsky, can you rephrase or break that question down into parts?
Okay. You don't know the frac volume pressures that Coterra is going to use on the 301 H well, correct?
Correct.
you acknowledge that those frac volumes and frac pressures are a extremely important factor in determining the behavior of fracs and the ultimate recovery of horizontal wells, correct?
Objection. Again, I believe he misstates. I didn't hear Mr. Gifford say extremely.
Fair enough, fair enough.
Sustained. Rephrase, please.
Okay. You acknowledge that the amount of frac volumes and frac pressures have an effect upon the creation of fractures, their direction, the volume of recovery, and generally speaking, the higher the pressure and the more volume, the higher the recovery. Is that an accurate summation of your understanding of fracking?
Yes, it does have an effect on it. Yes.
And we've established that you don't know what Coterra's frac volumes and frac pressures are going to be for the 301H, correct?
Correct.
So you cannot say with any degree of certainty that the Pride 401H well will recover more reserves than the Coterra Showbiz 301H well, correct?
I cannot say with certainty, no.
Now, I'm going to totally change direction and ask a question about directional surveys. During our research, we did not find any it's on the New Mexico OCD website. We did not find directional surveys that are required to be filed after a well is completed under rule for horizontal wells. And I believe the rule is 19.15.6.15.E subparagraph 1. Now so my question is, to your knowledge, Pride filed those directional surveys for the ghost state wells that have been completed?
Objection. This is completely outside the scope of Mr. Gifford's testimony.
Mr. Zimsky, why is this within the scope?
I'm asking him questions about being the prudent operator. It's a cross-examination question that I think, in being a prudent operator encompasses following the proper forms.
So this witness is qualified as a petroleum engineer. Ms. Shaheen, does a petroleum engineer have the expertise to form an expert opinion on being a prudent operator?
If I understand Mr. Zimsky's question correctly, he's not asking him to opine on any expert opinion. He's asking him a fact question about what Pride has or has not done in a regulatory context. So that's why I say it's outside the scope of Mr.
I see what Mr. Zimke, if you could frame your questions more to what I've just alluded to, that this is an expert opinion, expert witness in petroleum engineering. If you ask for his expert opinion, that's fine, within that scope of his field. If you're asking him for facts that are outside the scope of his testimony, then I agree with Ms. Shaheen, that would be outside the scope.
Mr. Gifford, would you agree that a prudent operator would follow Rule 19.15.6.15E subparagraph 1, which applies to horizontal wells, that requires the filing of a directional survey with the OCD after completion of the wells? Would you consider that to be a touchstone of a prudent operator? And if they didn't file it, would you say that that doesn't reflect well on their prudence in operating?
Object to the compound nature of the question.
So the form of the question, why don't you stop before the and? So Mr. Gifford, did you understand the question before he went to the and part of it?
Yes.
Go ahead and answer the question.
Yes. Yes is my answer.
There's your answer. Yes. What's your second part of your question?
So the second part of the question is the converse. If a operator didn't obey that rule, that wouldn't be a sign of being a prudent operator, correct?
Possibly not.
And don't answer this question because I think your counsel is going to object. I'm going to ask the question and then the Shaheen can object. Do you know whether Pride has filed directional surveys for the ghost state wells that are in existence? Okay. Okay, she's not objecting. So do you know whether Pride has filed the directional surveys as required by the rule that I went over for the existing ghost state wells?
No.
You don't know one way or the other?
Correct.
Okay. Now, we were talking about propellant and fluid fracking. Do you know the amount of propellant, I have a trouble with that word, in fluid that is using, that Pride is going to be using on a per lateral foot basis that is accounted for in the AFE?
No, I don't have that information.
Now, do you have any information from other wells that show a well drilled in the upper Wolfcamp A in lands without a frac baffle would perform better than wells drilled in the Third Bone Spring sand, where there's no frac baffle between the Third Bone Spring sand and the upper Wolfcamp?
No.
Did you try to research that?
Yes.
And so you researched it, but you didn't present any evidence one way or the other. Correct?
Correct. Correct.
Did you find some evidence?
No, I did not find evidence.
You found no, what else did you look at?
Are you asking me if I found evidence of Wolfcamp outperforming, of a well landed in the Wolfcamp outperforming the Third Bone Spring?
Yes.
Is that your question? No,
That's
I did not
part of the
find
question.
evidence of that.
And did you find any Third Bone Spring sand wells that outperformed Upper Wolfcamp without the frac baffle?
Yes.
And you did not put that in your report?
No.
Because that's damaging information, correct?
It could be.
And that goes against the gist of your argument here that you've been making, that the Pride well will outperform the Coterra. The whole time you had information that was counter to that argument. Isn't that correct?
Well, what I would say to that is that it's not apples to apples. It's going to be different geology as well. There's other factors to consider. It's not just, oh, well, because there is no evidence that means that's correct. The geology is different in the other area, and that doesn't necessarily mean that it's going to apply here. There's also depletion to consider. Whereas in the Third Bone Spring sand here, where Coterra is planning to drill their well, there is more depletion than in some of those other cases. And so what that does give the wolf camp is drilling your well in the wolf camp is going to provide for an upside there, an upside case that you have additional reserves in place and you can outperform despite depletion in the Third Bone Spring.
Now, Pride, based upon Pride's drilling in this area, is it fair to say that you believe that 4 wells per section, about 1,320 feet between laterals, is about the right spacing for this area?
I have no comment on that. I don't have an answer to that.
Now, Pride is spacing the Ghost State 401H well about 350 west from the west lease line. Is that correct?
I believe so.
And so this spacing is not centered on the quarter slot or swim lane, correct?
I believe so, but I'm not exactly sure.
Okay, that's all the questions I have.
Mr. McClure?
Thank you, Mr. Hearing Examiner. I do have some questions for Mr. Gifford. Mr. Gifford, extremely briefly, can you explain why fractures would tend to grow upwards rather than downwards?
Yes. So there's going to be a greater stress and greater pressure towards the center of the earth. So the fractures are going to want to grow away from the highest stress point, the greater pressure, which would be up, which is away from the core of the earth.
And do you have any fracture gradients or pressure gradient data for this specific area?
No, I don't.
Do you have any microseismic or any other data in this reasonable area to this project that indicates frac growth?
No, I do not.
If Pride were to drill and complete the well they're proposing, would it use a Martin frac schedule in that completion?
Yes.
And Martin frac fluids?
Yes.
In the Ghost 305H and 306H, why did Pride place those wells in the Third Bone Spring instead of the Wolfcamp A?
When that was being developed, I do not believe I was working at Pride Energy at the time, so I don't really think I could comment on that. But what I can say is they were very good wells.
You say they were very good wells?
Are very good wells.
Oh, are very good wells. Okay.
Yes. Were and are.
No more questions for this witness, Mr. Hearing Examiner. Thank you, Mr. Gifford.
Thank you, Mr. McClure. Ms. Shaheen, any redirect?
I do have some redirect, but I would really appreciate some time over the lunch hour to get my questions in order.
Okay, what time is it now? Oh, it's noon. Son of a gun. All right. It's 12:08 and it's time for lunch. So let's see. I don't know. I know that I eat here, but the party's probably, did you bring lunch with you or what did you? How much time do you need?
I'm fine with that. Whatever.
Ms. Shaheen, how much time do you need?
An hour would
An
be
hour.
good.
Perfect. So it's now 12:10. Let's say we'll come back on the record at 1:10. And Mr. Gifford, Ms. Shaheen will be asking you some more questions at that time.
Okay.
All right. And then Mr. Zimsky, you'll be ready to put on your case in chief?
Yes.
Wonderful.
Yes.
I heard you. Thank you. All right. So we will reconvene at 1:10. Thank you, everyone.